This petition name is there.
What anticipated bail? What is the allegation? Rachi? It's a big case also. How many of you are there? Too many?
Here
7?
so many.
11 people.
Some are arrested and
Released on bail, Your Lordship. The petitioner has no criminal antecedents also.
this petition no criminal. Exactly.
Okay. White authenticated
That's you are arrested and released on bail. That is already done.
So what is the stage of investigation?
Going on. Charge sheet has not been done.
Not been filed. No antecedents.
No one.
No.
The White order dated 21/4/2023. The State Council was directed to obtain the CD and file a report regarding the antecedents of the petitioner. Pursuant to that order, the CD has been obtained. The prisoner means that the petitioners have no criminality. Besides that, it is also from the CD that the investigation is still going on. The allegation as per the FIR is also regarding to the application that the petitioner has no criminal antecedent, although the present application is allowed. However, we do condition that the petitioners cooperate with investigation without pay, and so the other thing. And this shall on the yes.
Item 3.
Yes.
Item 3 may be zero.
Yes.
You can see the last one.
Huh?
You can kindly see the last one. So notice was issued to them. Issued to the informer.
2 weeks. Yes.
The notice out.
Third.
My lord, I am putting this one.
Yes. Yes.
Notice out.
I'll serve a copy to them, Your Lordship.
No. You tell. Interim order is there. Yes. What
can-
did you say?
My lord.
Lordship,
Madam,
can
this
you
is-
pass over the-
Pass over. Okay. Pass over. I'll just pass it over.
Obliged.
Get ready.
Okay, my lord.
Yes.
Obliged. Item 4.
Wait, please. Allegation under 307 on the last occasion, Lordship directed Learned State Council to obtain the criminal antecedent.
Hmm.
He has no criminal antecedents.
Have you filed the affidavit?
No, I have not filed the affidavit. He has no criminal
File the
antecedents.
affidavit. That is the direction. On 27/4/2026, petitioner was
The-
directed to file a comprehensive.
In case of
affidavit
antecedents, Your Lordship,
detailing the criminal antecedents, if any, and status of those cases. However, the affidavit has not yet been filed, hence release the matter. Huh? No, we will not under the mercy of see this, how the pressure. If the direction is there, you should have done it. Yes, let it come at the usual course. Yes, next.
Item 5.
Yes, next.
My lord,
Yes. Notice was issued.
last date is lordship's directed to file the affidavit. Here,
Directed to file affidavit and serve the copy itself same day, but they have not served. Copy must be affidavit.
ସବୁ ସାରୁ କରିଛି
ମତେ ଦେଇଥାନ୍ତି ମୁଁ instruction ଜାଣିଥାନ୍ତି ନା
ଅଫିସ
ଅଫିସରେ କଣ ଅଫିସରେ ମୁଁ ଫାଇଲ ଦେଲି
You,
ମୋ ପାଖରେ ଫାଇଲ ଅଛି ଆପଣ
I don't know why you are unnecessary trying to delay these matters. Don't want orders.
specifically
And you converted the court to the filing counter. You hold it and give it in the court. You know that these are e-courts and there is no place. How these things will be scanned?
ନୋଟିଂ
Something is there. The order dated.
affidavit noting ଅଛି my lord affidavit by the informant
Have you supplied the copy to him and he is
No.
supposed to verify it?
ମୁଁ ଏଟା
I'm
already
asking for the informant.
informant.
Let us see what is the case.
Yes, yes.
Yes.
My lord,
Yes.
without going to the majority, your lordship was pleased to, when I submit that both the parties are agreed to marry each other and to maintain a happy marital life, that reason your lordships granted me to file the affidavit and kept it for today.
Who has this file affidavit?
My lord, victim, they do say the victim and father of the petitioner and one agreement before the.
Yes, what do you say, madam?
Your Lordship, we are supposed to get married, Your Lordship.
Agreement between,
In the village ponds, my lord. Before the village ponds. Both parents of the
ready and willing to marry. What is the age of this girl?
20.
At the time
24.
of occurrence, it was
24.
70.
24.
Now she is a major. I am 24 years as of now. She was 17.
Pursuant to the order dated 27/4/2026 and 7/5/2026, the victim, oblique informant, has filed an affidavit inter alia stating agenda 3, 4, 6. 7th, 3 to 7. And then let counsel for the petitioner also relying upon an agreement purported to have been entered between the parents of the petitioner as well as the victim. Submits that in the village meeting also a decision has been taken that the petitioner will marry the victim. Musa appearing for the victim girl also submits that the victim has now attained majority. She is at present 24 years.
Yes, Your Lord.
24 years. And since the parties have already agreed to marry, and the parents have also agreed for the said proposal, she has no objection if the petitioner is granted anticipated, granted the relief as regarding to the interpretation and the settlement arrived between the parties without entering into the minutes of the case. Granted, yes. Next.
My lord, I can see permission to replace a
No,
copy
take
of
it, take
the
it.
original.
Photocopy. Next. 6.
Item 6.
Yes.
The last occasion,
Present petition earlier approached this court. Because in ABL number millers 5/24/26. This honorable court directed that
January 26, it was
this 26
petition shall not be arrested.
arrested and move further regularly.
move for the anticipatory ball.
Laws, future.
Hmm.
Apply the regular bail or be arrested. Situation demand.
For regular bail or pre-arrest bail as per situation demand. But till now she is not
Yeah.
arrested. Till now she.
The order means.
You just see the order, read the order. It says that the ABPL is disposed of with an observation that in case any such report is lodged in the future and the case is registered as a result and such arrest is apprehended, the petitioner shall not be arrested at least for a period of 3 weeks in order to enable him to apply for regular bail. Have you applied for regular bail?
No, pre-arrest bail.
You can't file now anticipated bail.
Till now,
That order is for filing regular bail.
for regular bail or pre-arrest bail.
Acha, or pre-arrest bail.
Pre-arrest bail.
As the situation demands.
Demand.
Okay, yes.
Actually, here is the millers have not obtained any seat. Millers.
Sorry?
There has not been received millers.
Thrice have given time. Last order just see.
Today itself I have contacted the ISC Chandrasekhar. He is supposed to give 2 days.
What is the allegation? I will record that also.
The allegation is that the informant has taken 30 lakhs from the petitioner has taken 30 lakhs from the informant, promising that a plot will be transferred in the name of him, a plot number and so on and so. But Milord, actually no such plot is in any ketel भी India plot किसी अमनार नथिला. Actually, Milord, actually what happened, the petitioner has came to contact to the informant in
You paid by cash or by check or what?
Milord, I have paid in check, but not in the December, not in the March 1. As per the FIR ଯାହା ଲେଖା ହେଇଛି ମାର୍ଚ୍ଚ 1 ରେ ଆମେ 30 ଲକ୍ଷ ନେଉ ସେମିତି କିଛି ନାହିଁ. ଆମେ ତା 2020 ମସିହା ଜାନୁଆରୀରେ 7 ଲକ୍ଷ ଟଙ୍କା ଦେଇଥିଲୁ.
FIR is registered by you,
No, Milord.
then who has registered?
By inform, I am for petitioner.
₹30 lakhs.
Vibhuti Bhushan Behera is,
Vibhuti Bhushan
Yes,
Behera
yes,
is the
I am.
informant.
30 lakh rupees he has to pay.
But actually, it is not fact.
You should, where is, have you implemented him? Issue notice to the informant to be served by the IAC, yeah? IAC. Release the matter on 19th. 19th. In meantime,
Interim protection, Milord.
no, in the meantime, see, you have taken money and thrice you have appeared also. In the meantime, the order dated 29/4/2026 to comply with the state council. Thrice I gave the opportunity. Next time I will have to grant the pay.
I have conscious Millers. I have also contacted IAC yesterday night itself
Yes.
to 11:30 Millers.
So serve the informant. Let us see.
Milord, till that
Serve
period,
it 1 minute. Yes. Next.
Item 7.
Putting it 25.
19th. Yes. Yes.
Item 7.
My lordship. My lord, offense under section 108. Last time obtained the directive to obtain the CD regarding any direct involvement or.
Yes. Got the diary. Is diary.
The investigation is in progress, Millers. Only
You have the case diary with you.
so statement of the informant is there. Complaint informant is there, Millers.
What is the allegation?
Allegation is that Millers, that lady petitioners blackmailing the son of the deceased and subsequently taken a money and they have committed Miller's suicide. Miller's.
This is means
Miller's 108 is there.
Com-
Miller's statement of
complainant
the
son.
informant I have read Miller's.
read.
Miller's. मुंशी भास्कर नायक स्वर्गत पिता स्वर्गत
Right, relevant part you read. Why?
ଏହି ସମୟରେ ଗଜପତି ଜିଲ୍ଲାରେ ଏକ ଝିଅ ଯାହାର ନାମ ରଞ୍ଜିତା ଅଧିକାରୀ ଏବଂ ଗୌଡ଼ ଗୋଟ ଗ୍ରାମର ପୁଅ ଯିଏକି ଖ୍ରୀଷ୍ଟିଆନ ଲିପି ଧର୍ମ
The commission of a cyber fraud and investigation is still going on. Therefore, the petitioner need to disclose by filing a comprehensive affidavit regarding this criminal. Okay? And the copy of the affidavit will be served on the state council to verify the claim and be listed. Yes, file the comprehensive affidavit.
Item 9.
Very good.
Lordship, I'm appearing on behalf of the informant, Lordship.
Yes. Yes, madam.
And 10 minutes, 9 and 10, case there is not available.
9 antecedents.
No, 9 and 10 item, case there is not available.
What about, madam, you are supposed to file affidavit disclosing your antecedents.
But I am sorry to say, I am appealing to the petitioners.
He is also
Today,
appealing.
Informant, Lordship.
Informant, okay.
Today I filed the affidavit before the Hon'Ble court declaring that
First May, the direction was there. Why have you not filed?
unfortunately the petitioners are afraid of arrest and are unable to
That is
appear
not
before
confident.
our chamber. So, my lord, all the offences are available in nature and except offence under section
How many
316.
cases are there against you?
My lord,
No case.
no case, my lord.
Yes.
My
What are the
lord,
allegations?
the allegation against present petitioner
Hmm.
that she illegally enclosed the property and sold to the informant. But my submission before this Hon'Ble court, after execution of sale deed, the said land is mutated in the name of the informant, and so also the ROR is published in favor of her. But unfortunately, when she so unsatisfied, dissatisfied to take the land, now the land is in possession of the informant. Try to get land, but unfortunately, it belongs to
ROR is also in her name.
ଆବାଦରେ ମଧ୍ୟ ଆମେ ତାର ଲ୍ୟାଣ୍ଡ ହେଇଛି
Yes, what do you say?
ପୋଜିସନ ଅଛି
Sale deed has been executed, the
Lordship.
revenue record has been transferred, and possession has been given to you.
Lordship, that Bhulek online Bhulek पठा जोटा सेमाने देउछन, that is not a accurate form. जो तेतेबेले आमे सेठी घर बनेबा पई गले, the other persons came and stated that सेमाने से जगहटा not only me आउरी 4 जन को बिकी जंती, and the informant जतले तहसीलदार ऑफिस रे जाई कि तहसीलदार को इंटिमेट कले, तहसीलदार कहले आमको जो पट्टा और जो ना रे देबे भुलेक रे चढ़िया पई आमे सेटा भुलेक रे चढ़ेबा, that is not a accurate form. आमे जतेबेले चाहे
Are you in possession of the land?
No, Lordship. Bhulek पठारे देखो जी जोटा online पठा, that is a fabricated document, Lordship. Breed रे भी ସେମାନେ fabricate କରିକି पट्टा number change କରିକି breed रे भी fabricate କରିକି ଦେଇଛନ୍ତି. Starting ରୁ ସେମାନେ fabricate କରିକି ହିଁ ବିକିଛନ୍ତି, Lordship.
Then
my lord, when the informant
you have sold it to 4 persons.
my lord,
Documented
my lord,
to them.
Everything is mentioned in FIR. ତାଙ୍କ ଭୁଲଟା ମାନିକି ବି Lordship ଆସିଥିଲେ ଥାନାରେ କହିଥିଲେ ଆସିକି compromise କରିବା ପାଇଁ.
Pursuant
And
to
further
the
ସେମାନେ ଆସିବିଲେନି.
pursuant to the order dated 1/5/2026, the petitioner has filed, petitioners have filed, only one petitioner.
petitioners, my lord.
The petitioners have filed the comprehensive affidavit, in the he is stating that both of them have no criminal heard so and so. Then consequently, informant Mrs. Panagre submits that the same piece of land has been sold to as many as 4 persons, and although her client has purchased the property, but on the basis of fraudulent documents, her client has been persuaded to purchase the property. Investigation of this case is still going on regarding to the nature of allegations, and taking into consideration the submissions made by both the parties, although not inclined to grant eligibility, however, the liberty is granted to the petitioner to surrender before the court the same day. Yes.
Item 10.
Elopement case, man.
Elopement case, my lord. Both are love each other and
Yes, notice was served by order dated 1/5/2026. It was directed to be served on the opposite party number 2 through IAC. But the IAC has not placed any report as yet. State Council is seeking 2 days time. 19th. Seeking an adjournment, release the matter on 19th. Yes.
Item 11.
Interim. The lordship may
19th. Yes.
May I please, your lordship? This case is under section 302 IPC. Earlier, your lordship was pleased to dispose of my bail application in 2024. In BLAPL number 6344 2024. And case was a case arrest on circumstantial evidence. Your lordship was pleased to direct that a material witness be examined within 6 months and come up thereafter. Paragraph 4. I'm in custody for more than 4 years. And all material witnesses have been examined. I have
6 months, after 6 months.
6 months.
Which
That
was
is
the-
order of
2024, yes.
2024.
Now it is examined.
Over. Material witnesses, I have appended all the annexure 3, I have annexure 2, given the
Yes.
copy of all the deposition of the material witnesses.
You have the.
No one has.
Yes, I have the deposition attached with the
Yes.
bail application. But another material witness, Sarju Kumar, he has not been.
No, say, examine him.
Let us see who are the material witnesses,
No.
whether what they have said.
Yes, my lord. He stated that I am placing.
Who?
Sarju Kumar,
Who has not been examined.
not examined.
No,
Hey, those who have been examined,
They have turned hostage.
huh? All of them are.
Hostage. Sarju Kumar have two statements.
He is the only eyewitness. Sorry,
No, he is the last-
sorry,
last scene.
last in.
Hmm.
And who else is the last in?
My lord, Sarju Kumar.
Only one.
Another, Arjun Khadia.
Arjun Khadia is also one of the last in. He
Arju?
turned Khadia,
Arjun Khadia. Examined at PW8.
turned hostile.
Turn hostile.
What will you do with this?
And Sarju Kumar have two statements. One is saying that I have last seen, another is saying that I heard from the informant. Thereafter, my lord, that witness has also been examined as PW10.
ନା ସେ ଦୁଇଟା
So-
different. ନା ମୁଁ
ଟିକେ ସାର୍ ଟିକେ
ଚାର୍ଜସିଟ୍ ଟା ଦେଖନ୍ତୁ.
ହଁ ମୁଁ
I have examined
କହୁଛି
charge-
ସାର୍ ସର୍ଜୁ PW10 ଏକ୍ସାମିନ୍ ହେଇଛି ସର୍ଜୁ କୁମାର ଗିରି ନା ସର୍ଜୁ
Sarju
କୁମାର
Kumar
ଘାସି
C.
ସେମିତି ଚାର୍ଜସିଟ୍ ରେ ଆପଣ ଷ୍ଟେଟମେଣ୍ଟ ରେ କାହାର ୱିଟନେସ୍ ଦ୍ୟାଟ୍ ପର୍ସନ୍ ଇଜ ଦ ସେମ୍ ପର୍ସନ୍
You read the statement of Arju Khadia.
Khadia.
What is your statement?
Sarju Kumar.
No,
ଅର୍ଜୁନ ଖାଡିଆ
Khadia, you read. PW8.
He turned hostile.
I know, but what has he said? Because
He
he was
stated-
also along with the Sarju.
No.
नो ସେ
Separately. Sarju in his house, Arjun in his house.
ସେ ସମସ୍ତଙ୍କର
ସେମାନେ ଦେଖିଲେ
Hmm.
ଯେ the present petitioner holding an axe stained with blood came out from the house of the deceased. They both did.
Separately they have
So
said.
they have separated.
similar types of witness ଦିଟା and ଅର୍ଜୁନ ସର୍ଜୁ କୁମାର two statement man
And this is regarding the last scene.
last
And what else?
nothing
Out leading to discovery hostile.
Oh, hostile. What is there?
Only my
4 years
my
in
submission is
4 years in custody
I have examined the
There's nothing.
deposition. Only this is the witness remain. ଆଉ କେହି ନାହାନ୍ତି କେବଳ ଏଇ ଗୋଟେ ସାକ୍ଷୀ ଅଛି ଆଉ ସବୁ ହଷ୍ଟେଲ ହେଇଛି.
ତାହେଲେ କଣ କରିବ ତମେ? Even if he supports, you can't do anything.
Chain
He
complete
has
ହବ
to
ନା.
be-
I admit
He-
chain complete ହେଇପାରିବନି.
Even if he supports fully,
Hmm.
what will happen?
ନା chain complete ହେଇପାରିବନି.
ତାହେଲେ why should you keep him inside?
in custody for more than 4 years
Petitioner is accused of also allegation is the petitioner also. Earlier, the petitioner approached this court by filing BLAPL number 6344 of 2024, which was disposed of on 23/9/2024, inter alia passing the following order, para 4. Between 23/9/2024 to till date, how many witnesses have been given?
so far 10 my lord
Huh?
10.
witnesses have been given.
In
None of
the
the
rejection order
witnesses
also
have
mentioned.
supported,
out of 17 charged
Mr. Naik, counsel for the state, submits that one more witness, that is Sarju.
Sarju. Sarju Kumar.
Sarju Kumar is yet to be examined. The prosecution has cited that witness to establish the circumstances for last scene. In that regard, another witness, namely Arjun, what is that?
Khadia.
Khadia has been examined as PW8, who has also not supported the prosecution. Insofar as to establish the leading to discovery, which states, who was examined?
Leading to discovery, with name is
Examined. Those with them, examined as PW,
Mala Sarjuk Ghasi and Muni Khadia.
PWs,
Sarjuk Ghasi, PW,
Muni Khadia is PW9, and
PW8.
Munikhoda PW9.
and Sarju Khadia.
Sarjuk Ghasi,
PW10.
Ghasi, PW10.
PW10. Both the PW9 and 10 have also not supported the case. Therefore, the prosecution, as per the evidence which is borne on record as of today, the prosecution has failed to establish its case regarding to bring home the establish the case regarding the discovery leading to the discovery leading to the disclosure, and the last theory is also has been failed to be proved by the prosecution. The petition region custody since
May Premier. ଏତେ ଯୋଉ ଅବଜରଭେସନ ହେଲାଣି ସେ ଆକ୍ୟୁଟାଲ ହବ ତେଣୁକରି କିଛି ନ କରି
observation କରିଦେଲେ କ'ଣ ଫରକ ପଡୁଛି?
କଣ ଅଛି 10/4/2022
Without writing, how can I believe him? I have to write. These are the facts. You can't deny these facts.
10/4/2022
Those are these are right. Yeah, I just modified a little bit without the prejudicial there. Those are right. Granted bail with the subject to confirm that the petitioner shall appear. This is accused shall appear for the trial court on which case are very failure to appear in a single day without reasonable cause to the satisfaction of the trial court shall entail cancellation of bail. Cancellation of course the concession of bail granted by this court. It is open for the trial court to issue course with process in case the petitioner remain absent before proceeding. Yes. Yes, next.
Item 12.
commercial quantity brown sugar.
I'll call for CD. Call for CD.
CD not yeah.
Let the CD come. Please. Yes, next.
Item 13.
May I please? Yes, your lordship was pleased to direct the petitioner to file an affidavit. Father, of course, had filed an affidavit 20B2 similar. And your lordship on the last occasion directed to the security, local security has to sworn an affidavit. And accordingly, I filed an affidavit. Allegation is, my lord, 6 persons from 2 drivers of 2 cars, Desire car.
Have you filed the affidavit?
Yes, 2 affidavits.
Give a copy. Let it
Yes, I have given.
No, not given.
Sir.
Pursuant to the order dated
He is in custody since
21/4/2026. There is a comprehensive affidavit has been filed. Advance copy of the same which is supplied to Mr. Naik, who shall verify the same and report to this court.
My lord, I mean that saw item, my lord. I have also filed that
Give
comprehensive.
the copy. Same.
My lord,
may we take it up next week?
We'll see. We'll give it. Huh? Counter it. File the
6/2/2025.
Scan and
I have filed it. That is at Clark jail.
it's all right. Give a copy to him.
My lord, I am serving it right now. My lord. May I keep it to next week, my lord.
Yes. We'll see next week only. Wait, next week only.
Petition is the only driver. There is no
They are
consequence.
outsider.
I filed that local security.
Have you planned it for vacation along with your client?
No.
Then wait.
I am in my lord's hand. My lord.
Wait. I'll give a date.
Affidavit copy taken.
21 or 20.
Tuesday.
Yes.
Correct, lordship.
Item 12, your lordship specifically kept, because I have given all the charge sheet, everything.
Item 12.
I have given everything.
My lord, item 14.
I've called for CD.
My lord, I have given everything in the bail application.
My lord, item number 14.
1 minute, sir. 1 minute. Item
କେତେ item?
12.
12 CD ଆସିନି.
That's what he says. Have you checked it up? 19th, keep it on 19th. Huh? In meantime, the CD to come. Yes. 14, yes.
Item 14.
My lord, item number 14. I am not pressing the same.
Not pressing, okay. Not pressing, yes. 15.
Item 15.
May I please?
Yes, sir.
both the petitioners, my friends petitioner and myself, are the students, they were prosecuting their engineering course. And in due course, what happened? A whole account was opened through which some transactions were.
What is this? I have received the case diary. I am placing the note of the investigative officer. I may note here that the SIM card registered with the Indian Overseas Bank, Narendrapur account number so and so, was in possession of co-accused Subhrajit Barik and was being used in the seized Android mobile phone number so and so. During investigation, it was ascertained that Subhrajit Barik had installed a third-party application. Subhrajit Barik has installed a third-party application on the said mobile phone through a link provided by Telegram channel operator. Subhrajit Barik had joined the said Telegram channel, which assured payment of fixed amount of money in exchange of for providing bank account details and the corresponding merchant QR code. As per the arrangement, whenever Telegram channel operator intended to transfer funds to another bank account, an OTP would be generated and received on the above mentioned Android mobile phone. The installed third-party application was configured to automatically read the OTP message and facilitate the transfer to specified amount to the intended beneficiary account. Since the Telegram channel operator did not have physical possession of the SIM, it was presumed that he has accessing internet banking facility of the said account using login ID and password credential. Access to internet banking required an IP address. Therefore, it is necessary to obtain IP address used by the operator to access the internet banking account in order to ascertain the corresponding physical location linked to those IP address. माने एंका ऑपरेशन को मधे एमती करचोदी ताको मधे ट्रेस आउट करिवाटा
What is the amount?
72 lakhs were transacted, not a single.
See, the modus operandi is so critical modus operandi.
Yes,
very,
yes.
very difficult.
Yes, I am coming to that point.
Yes.
As I have addressed before the Honorable, both of them are the students. That is unbelievable. They were taken into custody on 23 to 26. In the mean period, charge sheet has been 22. And charge sheet has been submitted. And offences alleged against maximum punishment is 7 years. And it is triable by magistrate first class. In view of this background, my humble submission whether it is prudent to keep them behind the bar till the conclusion of the trial or to release.
I am only interested to know that how many cases are reached.
No case. No, absolutely.
I have written para 4.
It was mentioned in the charge sheet.
Instruction is no case, no criminal
No
antecedent.
case.
But
The problem is these people are
threat to the society again.
That is this has become a menace, I tell you. This is much more dangerous than that erodes the economy of this country because of these big frauds. But how many days you will keep them inside? That's another question. Because these people are young people, you know.
Engineering students.
Let their parents.
That is the reason it is very difficult to
My lord, let
find
their
out the
parents.
modus operandi.
My lord, let their parents file an affidavit that they could take all sincere step to.
Parents have what is the use of
କିଛି ତ ମାନେ total ଛାଡ କିଛି ତ ହବ.
Let them go and appear in the police station.
Relation will be surety.
Police station for 6 months.
Yes.
Parents
Relation could be.
Why should parent will go to police? People have
କିଏ ତାକୁ ଜଗିବ ଏମାନଙ୍କୁ ଆଉ
Here,
କିଏ?
see, these people are beyond control, I tell you. These people are beyond control. You make any condition, come to the reality. What the parents will do? The parents may not be knowing. These people are for making quick money, they must be doing. These engineering students, they must be into drugs and so many things. So no, parents are also maybe troubled because of these people. You can't do anything. That's the reality. What the parents will do? And traumatize the parents to go and appear in police station is another additional problem for parents. So let them appear before the police station. And disclose you have already filed the charge sheet.
Yes. Charge sheet filed.
So all are documentary evidence in true sense. So putting them behind bar for like that.
That's true. I am.
You give that report. by the order dated 27 and 20.
Well, I have flag mark.
30th April 2026 and 12/5/2026. The State Council is directed to obtain the CD that will produce the court. And the flag mark,
Well,
the IAC. This which flag mark?
yellow color flag mark.
The
Note.
from the CD, the result of the CD reads as this one. The petitioners are in custody since 22 to 2026. Charge sheet has been filed on
Charge sheet on 20th April 26.
2026. And both the petitioners are young students of 21 year age. 21, ye kate? The other one? 21, 20 and 21. Yes, yes. The petitioners have also filed a comprehensive affidavit disclosing that they don't have really criminal background. And
No criminal.
Both the petitioners are pursuing their engineering course.
Yes, Parla Maharaj Engineering College, Baroda.
Engineering course.
ये होते Sri Sri University.
In different colleges. Regarding it to the Sri Sri University.
Yes.
Regarding it to the therapy and period of custody, and the fact that the citizens are young engineering students and inclined to enhance regularly, particularly for the fact that the charge sheet has already been filed and the entire case is based on documentary evidence.
Yes.
Documentary evidence. However, to allay the apprehension of the State Council that the modus operandi obtained by the petitioner to commit such crime indicates that they may repeat the same crime. Hence, the petitioners shall appear before the physically appear before the concerned police station, police station so on the last Sunday of every month, at least for a period of 6 months.
Yes.
6 months. In this sense. Yes.
Problem. Item 16.
Because in this case, the offense alleged is not 420, 468, 471, 506.
Yes.
The allegation is that in the year 2021, when the present petitioner was working in a bank, the informant says that he had availed a loan of rupees 30 lakhs, but instead of granting a loan of 30 lakhs, it was made 60 lakhs without his knowledge. The affair was lodged after 3 years. Since 2023, he has been
Custody since?
Custody since 18 to 2024. Sorry, 26.
Yes.
And charge sheet has been submitted on 18/4/2026. In the meantime, a complaint was made before the ombudsman, and the ombudsman has given a finding. Lordships, pass an order. I've given the copy to my friend the other day. My friend
Yes.
wanted a copy to that.
My lord, kindly have a glance to ombudsman observation.
Page 4.
Page 5.
Can you give that?
No, 4 टिके साथ 4 देखे देला पर 5 बुझगा सर. Page 4 right? The evidence.
Copy I don't have anyway.
Right, given a copy to a
Yes.
lawsuit that day. I think my friend has given an affidavit. Say
Annexure A/5.
my friend has given the same copy to a lawsuit in an affidavit.
Page 20.
Page 20.
No, affidavit.
Yes.
Page 4 of that
Award.
Yes.
Yes.
The evidence furnished by the complainant to the ORBIO, including deposit slips, loan account statements, and sanction letter, were duly reviewed
You
by
are
the
reading 4. You are reading 4.
page 4 Millers.
No.
First point.
First.
Paragraph number in the
First dot.
Huh?
Evidence furnished by the complainant to.
Furnished by the complaint to ORBO, my lords. That is a page.
Lordship,
my lords,
page 23.
23.
Lordship, may kindly page to page 23.
Yes, yes.
The evidence furnished by the complainant to ORBI, including deposit slips, loan account statements, and sanction letter, were duly reviewed by the RE. However, these documents appear doubtful. Certain transactions worth approximately 30 lakhs between Mr. Swine and the complainant appear suspicious. These could either have been deliberately omitted from RE records by Mr. Swine or may not have occurred at all. A forensic investigation commissioned by the RE confirmed that the statement of account provided by the complainant does not match with the RE system generated statement. The forensic report concludes that the complainant's version appears fabricated. Then, lords, of the 4 deposit slips produced by the complainant, only one entry of rupees 2 lakhs dated 27/10/2021 is reflected in the RE records. The other 3 purported cash deposits dated 30th of
Not traceable.
yes, my lord.
Okay.
Then third,
Ultimately, what is the order?
ultimately the ombudsman directed to reverse 30 lakhs to his account, my lords. So he is no way agreed.
You got back your money.
No, no, no. I am fully agreed.
Are
Like,
ରୁହନ୍ତୁ ଅପେକ୍ଷା ଆପଣ କହିସାରନ୍ତୁ.
yes, you got back your money
No, no, I am not. My lord, bank has been moved for appeal.
against this.
Yes, and bank says that the entire order of the ambushed person is wrong. I have also annexed, my lord, kindly peruse
That's a
the.
different pedestrian altogether.
Oh, my God.
This is not recovery proceeding as such.
Okay, my lord.
Yeah. As such is not recovery. I
Because
can,
my only limited prayer before your lordship,
yeah.
is a private, bank is complete private organization. Manager is who remain in custody, he is also private. But who will be responsible? My 30 lakhs which I have been deposited. That is my sole question. ଆଉ କିଛି ନାହିଁ.
question to the court under the court.
ନାଇଁ ନାଇଁ ମୁଁ ସେ କଥା କହିନି ଆପଣ ତ ଆମ୍ବୁଡ୍ ପର୍ସନ ଗଲା ଥର ଦେଖେଇଥିଲେ ବୋଲି ମୁଁ କହିଥିଲି ଆଫିଡେଭିଟ୍ ଦେବି
Sir, ଏତେ ରାଗୁଛନ୍ତି କାହିଁକି?
No, see, I'll
Don't
tell
be
you. I'll
agitated.
tell you. This
No, no.
you can initiate a proceeding for recovery.
No, that I have.
That you have started.
Then that has been
That is
started.
another process.
Yeah, that has been already started.
But see, criminal cases are not recovery proceeding as
criminal
simple
case
as that.
violence is ସମସ୍ତଙ୍କ
My lord,
ticket କୁ ଜାଲି କରିଦେଇଛି. Another things.
The petitioner is a banker. The petitioner, the one loanee, the informant, he handed over 4 checks to the petitioner and petitioner misapprehended. It is a clear case of 409.
That's right.
Yes.
But see, all for everything is made out. But the fact remains all are documentary evidence. Why
Well,
will you keep
Yes,
him
my
inside?
lord. Yes, my lord.
We'll face the trial.
Life imprisonment is there. Here, my lord, 409 life imprisonment.
I don't know that is there.
ଅଛି ପୂର୍ବରୁ
ନା ନା ପୋଲିସ ଯାହା ଲଗେଇଲା
ଆରେ ସାର୍ ଏଥିରେ ଆପଣ ସବୁ
Charge sheet has been filed. Charge sheet has been filed.
yes, charge sheet has
So
been
what is the offense?
my lord, offense, my lord, 420. But the petition, my lord, court is not bound to accept the report of
That's
the
a
police.
different story. You can't imagine that he might have done so.
What is the fact?
As of today, what is there in you on record? One is ombudsman proceeding where he is trying for recovery of that. That appeal and everything is going on. And second is criminal case. Everything you have seized and you file the charge sheet. It's 420 and all.
Na, seize
He
kichi.
will be hanged. No problem. You hang him.
My lord, prosecutor is questioning the
Yes.
efficacy and efficiency of the
Yes,
prosecution.
yes, definitely. If the
What
police, if the police will submit the charge sheet in the wrong offense,
Are you
I will definitely, I will write to the SP, my lord. Definitely.
right? Then once it is filed, then you can
My lord,
you can move an application for recall of the order. As of today, there is nothing.
my lord.
What to do? You move you advise your
Definitely, sir.
police to enter the
In one occasion, I have-
173(8) is open.
at any time, police can reinvestigate into matter. I will suggest for reinvestigate.
Do it. Let us.
Lordship, may I pray one thing? Lordship, may impose some cash security.
Supreme Court has
Supreme
asked
Court
not to do all these
time
things. That's
and
the whole
again.
difficulty. I will definitely write that after his release, he will go for mediation.
Huh,
You have
they
to go
belong
for
to
mediation,
the,
I go to
interestingly, my
mediation.
friend will not disagree, belong to same village, they were friends.
I'll ask him to go and participate in the mediation process. But ultimately, you are interested in your money. You are not interested
No,
for
no.
anything else.
No, no.
Obviously, you need your money back. And they will prosecute him whatever.
Yes.
And I'll suggest you to go for mediation and get back your money. Let them prosecute him whatever. That's a different story. I know.
My lord, it will be better if your lordship release the petition on interim bail and direct for mediation.
It is brought to the notice of the court that the instance of the informant in amusement proceeding was initiated before the Reserve Bank of India, Reserve Bank integrated amusement in Bhubaneswar, integrated amusement at Bhubaneswar. Under clause 15(1)(b) of the Reserve Bank integrated amusement scheme 2021, an award has been passed in favor of the complainant. Award of 30 lakhs. That is passed. Then counsel for the complainant submits that this award has been assailed by the bank before.
Even the executive director of Reserve Bank of India had annexed AYC.
Ombudsman, your lordship, it is.
Before the competent authority.
Appellate authority.
Before the appellate authority. Before the appellate authority, which is pending. Pending. He further submits that he has initiated the criminal proceeding as he has been defrauded over 30 lakh. He's interested to get back his and to get back the paid amount, and hence he has not only filed the file but also initiated proceeding and in the ambushment proceeding for the recovery of them. Mr. Samantraj and counsel for the petitioner submit that the petitioner is in custody since 18 to 2026. Meanwhile, after investigation, charge sheet has been filed on 18/4/2023. Allegation and investigation reveals that the entire case hinges upon the only documentary evidences. Detaining the petitioner in custody would serve no fruitful purpose. Moreover, he submits that the FIR was registered after 3 years.
Yeah.
After three years of the allegation. Taking into consideration, Mr. Naik, appealing for the state, submits that in fact a case under section 409 BNSS 468, 468, 67.
468, 471, 420.
And 420 in fact made out. The graver offense under section 309 is made out.
409, my first.
409 is made out. BNS is, na?
No, please, old act.
No, BNS is what is the provision?
No, it has IP.
It has IP range.
409, 468, 471, and 467, 68, and 71 is made out. However, the investigating officer has only filed the charge sheet under section 420 APC.
471, yes. 409, my friend says only 409.
Deleting the provision under section 409
is made out, but
IPC. Hence, he further submits that he would adequately advise the investigating officer to reinvestigate. Since as of today, the FIR has been the charge sheet has been filed for offense under section 460, 467, 468, 471, and 420 IPC, and the petitioner is already in custody since 18 to 2026. Charge sheet has already been filed, and the complainant has also initiated a proceeding for recovery of the fraudulent amount by resorting to the proceeding before the ombudsman. I am inclined to enlarge the petition on bail, granted bail. Fine. It is also after the petition is released after the petition is released on bail, the petitioner shall appear before the mediation center. On 21st of this month, and the mediation cell shall issue notice to the all stakeholders and explore the possibility of settlement.
Beg pardon me, one line. My friend said that the FR has been after 3 years. Within 3 years, before 3 years, he made an agreement with me for repayment of the
But the FIR that is his statement.
Yes, yes. That's why it has been.
I have not expressed it. That is his statement.
Yes.
Maybe wrong
So the
statement.
agreement is that I have also filed the agreement. Okay.
Yes.
Item 17.
Yes.
May I please also? On my interim application, last date my lords is directed to take
Yes, have
instruction.
you verified?
Over phone, I have received the instruction that paralysis. Achha. I have not received the.
One side of the body was paralyzed, my lord, the father of the petitioner.
Father of the petitioner.
Yes,
I'll
for
do
his
this for 1 month. This is only for interim bail.
interim bill.
Okay.
The main prayer is for regular.
Main prayer for
Regular bill,
Regular-
but I filed a miscase for interim bill.
I'll dispose it up and renew your bail plea after surrendering. Okay.
Okay.
Right on. Although the petitioner has filed the present petition exceeding the order dated 27/12/2025, whereby his regular bail application has been turned off. But during the pendency of the present petition, he has moved IA number 231 of 2026, seeking interim bail on the ground that his father is terminally ill. And he has also enclosed a certain document with this with the IA. On 29/4/2020, this court directed the State Council to verify the authenticity of the documents enclosed with the interim application. Mr. Naik submits that although he has not received the
Written instruction, but
written instruction from the IO, but he has the IO orally informed him that the father of the petitioner is paralytic and suffering from various ailments. Regarding it to the submission made by both the parties, I am inclined to enlarge the petitioner on interim bail for a period of 1 month from the date of release to the conditions being and proper to be imposed by the codification. And insofar as next paragraph, insofar as the regular bail plea is concerned, the same is the same is decline in this case. Decline in this case. However, liberty is granted to the petitioner to renew the bail plea, the regular bail plea, before the trial court after surrendering on surrendering after completion of the interim bail period.
5 days may same because they are staying.
45 days. 45.
but in case of failure to appear, people surrender before the court, the court will proceed.
Can issue forcible
Okay.
process in the event the petitioner failed to surrender after expiry of the bail period. It is open for the trial court to issue forcible process for ensuring these release. Yes.
Item 18.
18 notice ଯାଇଥିଲା rape and murder. Notice acknowledgement.
Okay, notice.
May I say one thing?
That was directed to be served on the
Lordship.
informant opposite party number 2 by the order dated 29/4/2024. However, the State Council has not received the report for the service as today, and see that it's 1 more week.
May I say one?
Yes.
May I say one thing, my lord? Petition is languishing custody since 2022. छुट्टी पूर्वରୁ ଗୋଟେ
In the vacation, first half. Yes.
ମିଲଟ ଏଇ
ଛୁଟି ପତ୍ର ନେଇ ଆସିବ।
22 is not possible at all. 22 you are requesting.
21 ରଖ।
The last 2 days will be virtually no work kind of situation. 22, I'm saying in the vacation, first half of the vacation. First half.
First or second available ହେଇଗଲେ ମୁଁ ସେଇ
No, you can't choose the judge.
No, that is not, my intention is not that, my lord. Well, in fact, the notice ଟା ହେଇନଥିବ ପୁଣି
In the lighter way I said, but first half. Okay.
Item
Yes.
19. May I please tell us?
Now, the offense against the petitioner is under section 20B PVC and plus.
Yes.
And 40 kg ganja was seized. And the 28 kg.
Yes.
And they are in custody since 11/10/25.
11/25.
And final PR as
Serious with God.
Yes, he did.
Yes. Yes.
No CA.
Huh?
No CA.
No CA. Yes. It is recovered from the conscious position.
Yes, fine. Commercial quantity, no CA, but custody pay.
25. What is the stage of trial?
Investigation going on.
Final
Final pair he is.
What is the stage of trial? Just tell me. If any witness is examined.
Trial he.
Starting.
final pair
Charge.
submit
Charge frame.
That of instruction I left in. Whether charge and
I don't know. The State Council is to obtain the status for the trial by the extent of hearing. First half of the occasion, least first half of the yes. Next. Item 20.
My lord,
First half of the occasion.
item 20, may I please, my lord. Have the last.
Yes, next. Item 20. CD.
My lord, charge sheet has been filed and the case is posted for evidence of the victim, my lord. So with that,
yes,
CD
no,
also,
yes, I have not received the case diary. The victim is pregnant for 29 weeks.
she has given birth to a female child on 16/12/2025.
Foxo is there. No, sorry.
Audio button, Foxo nahi.
29, I have not received the case diary.
But my lord,
The case diary.
charge sheet has been filed and the perusal of
Case
all.
diary, I have asked for case diary. Charge sheet, do you have the copy of the charge?
Yes, I have an next.
Give a copy then.
It is with the application, bill
You
application.
have the charge sheet with you, just see.
Charge sheet submit ହେଇଛି.
Charge sheet submitted 164 Sorlani, and as per the rejection order, she was delaying the trial, my lord.
164 statement is there with you.
Yes.
No.
Yes.
ନା ନା
Page 8.
ମାନେ ଏଥିରେ page 8 164 ଅଛି ସେଥିରେ ସେ ସପୋର୍ଟ କରୁଛି I am placing the allegation. ଏଇ ବର୍ଷ ଏପ୍ରିଲ 4 ତାରିଖରେ ମୁଁ ମୋ ଆଈ ଘରକୁ ଯାଇଥିଲି ସେଇଦିନ ଜିତେନ୍ଦ୍ର ବେହେରାକୁ ମୁଁ ମୋ ଆଈ ଘରେ
Petitioner is agreed, although petitioner, as I said, the order dated 19 to, you have, you're asking for regular bail?
Regular. It has the interim bail.
Yes. No,
Interim application, my lord,
Interim
regular
application.
bail.
Although the petitioner has said the order dated 19 to 2026, whereby the trial court has rejected with regular bail. But during the pendency of the petition, interim application being 257 of 2026 has been filed, seeking interim bail for a period of 2 months.
Yes.
On the ground that his wife is terminally ill. On 1/5/2026, the direction was issued to the state council to verify the authenticity of the documents submitted along with the application. So let me appearing for the state submits that she has obtained while instruction that the delivery date has been fixed made oral instruction that the delivery of the baby is fixed on 29/29/2024, and but verification of the document is not yet been made regarding it to the aforementioned. Would be appropriate that the trial court shall verify the authenticity of the document and the aforementioned in the application. Shall release the petitioner on interim bail for a period of 15 weeks proper, every week is proper with the condition, with the condition. insofar as the regular bail application is concerned, we can entertain at this stage. However, overview is answer to the petitioner to renew the regular bail fee after surrendering on the expiry of the into bail to be granted by the trial court. This subject the petition is portion. Yes.
That is sub-item manual, but we can take note after vacation manual.
Sub-item after vacation.
Lordship disposed of this bill application. Your Lordship disposed
Yes,
of
yes.
this.
Yes. And this one.
May I please, Your Lordship? The petitioner has been in custody since 5th February 2026.
CD would be required.
Yes, he has been charged for the offense of.
CD would be required.
You have not received.
Your Lordship, on the last date, Your Lordship will directed to obtain the CD.
152/2026 CD. Appropriate CD was called. On which time granted. Please see my terms. Yes.
25.
My lord. 109, along the office, my lord. Last second, Your Lordship directed to the state to obtain the injury report, my lord.
Yes. Yes. Multiple injury words.
Simple.
Simple in
All
nature.
are simple.
The vital part of the body, scalp ray achi. And she's a lady.
Antecedent.
And
As for the registration copy, one complaint.
You are a lady and you have antecedent.
Submitted, my lord, injury.
victim is a lady.
Huh?
Victim is a
No,
lady.
she is also lady.
No.
Suman Malik.
My lord.
Suman Malik is a man.
Man.
The victim is a lady.
Suman name is that. On 1/5/2026, the period of the case was called for. The petition and counsel of the state level produced the CD. The result of the CD reveals that although the victim, still, Rasmita Cooperative, received 5 injuries, 1, 2, 3, 4, 5 injuries, but all the injuries are simple in nature. You have one antecedent. One antecedent. Petitioner by
Registration copy, my lord.
where have you written that?
My lord, page 15, my lord. The petitioner has one complaint said, investigation going on.
Order dated 18/3/2026. You are in custody since
28 to 23.
28 to 26 custody. Regarding the period of custody, for the IAC, for 3 months. Yes. Yes.
Item 26. My lord, the offence alleged against the present petitioner is 20B Roman 2C of the NDPS.
CD you got?
No, your Lordship. CD and CA would be.
My lord, one thing I'll just. I was in custody from 2017.
17.
15/5/2017. I was granted interim bail in the year 2019.
Yeah.
Thereafter, I jumped the bail. I have overstepped the interim bail. I was arrested on 5th June 2024.
Escaped from the custody when?
No, I was granted
bail. Okay.
interim bail.
Yes.
I did not surrender. I was absconded and I was arrested. I surrendered to the judicial custody on 29/6/2024. And there is no substantial progress of
NBW issued on?
My lord, NBW issued in 2019.
Okay. 17 you got back. Because of you only the trial is delayed. What to do?
Out of 23 witness, only 11 witness examined till date.
But if you absconded or what?
There was no witness.
See, you should be happy that you are arrested on 29/6/2024, within these 2 years.
My lord, whatever is there on the record, I will not withhold.
Get the CD and status of the trial, status of the trial, CD and antecedent.
My lord,
What about antecedent?
there is no antecedent.
No antecedent. Have you said anywhere?
No, my lord, your lordship,
File an affidavit.
I'll file an affidavit that no antecedent.
Yes.
My lord, can it be on 19th, my lord?
19th, he can't. She can't.
Very difficult.
It is not possible.
Any day,
First half in the vacation.
my lord, any day in vacation, as subject to your lordship, 21st, 20th, any day.
What the date possible give it? 21st.
28th, for vacation.
Yes.
I'll file an affidavit that I have no antecedent. That
Yes.
the family member will file.
Yes. 27. Yes.
27, your lordship. The case under section 395 dacoity requires some more time for CD and CE, your lordship.
My lord, one thing, my lord, BLAPL 4217. He is standing on 4217. Vijay Kumar Sahu. He is standing on different footing, my lord.
4217, yes.
Only received 20, and he was working as a jewelry appraiser in Canara Bank, my lord. He have-
Canada.
Yes, my lord, Canara Bank, my lord.
Canara Bank.
Yes, my lord. But he have received some gold on
Why the CD is not there?
CD is not the.
My lord.
Call for CD.
My lord, it was earlier, my lord, on 2026.
Let it be on 21st.
Yes.
Right. By order dated 4/5/2026, up to date CD was called for, but let was for the state. CD.
My lord, I have annexed the charge sheet.
Huh?
I have annexed the charge sheet.
Let us look at this. Last opportunity in the on 21st. 21st. Yes. 28. Yes.
May I please, let's say, the petitioner is in custody since 2/9/2025 and charge sheet has also submitted 28/2/26. And no criminal antecedent, and petitioner, wife of the petitioner has also filed the affidavits.
Yes.
See, this is from outside, your lordship has directed that an application affidavit should be verified.
My lord, charge sheet also submitted no absconding, my lord, no
What did they recover?
chance of tampering.
Recovered how much?
Pardon, lordship. 26 kg.
26.
26 kg.
He shall be released subject to verification of for the
Yes, lordship.
contents of the affidavit.
Yeah, absolutely.
Okay.
Yes.
Petition indication of also allegation in the file and so on. So, by order dated 5/5/2023 and 2026. The petitioner was directed to file a comprehensive affidavit disclosing the criminal antecedent and the permanent address as well as details of local security. Pursuant to the said order, an affidavit has been filed by the mother of the petitioner.
No, sir, no, my lord, wife of the petitioner.
Wife of the petitioner on 7/5/2026. The petitioner is in custody since?
Since 2/9/2025. 9/2025. 26 kg ganja.
26 kilo, na?
26.
26 kilos. And which is custody in 2/9/2026. And as
No criminal antecedent already filed.
as per the affidavit, filed by the wife of the petitioner, there is no criminal antecedent. Regarding the information, granted will, the trial court can release the petitioner on a regular basis, subject to verification of the contents of the affidavit filed by the petitioner. So affidavit dated 7/5/2026.
Hello, yes, sir.
Yes. 29. This will be verification of the petition. 29, yes.
29.
Non APS for the petitioner in the interest of justice, adjourned to application, yes. 30.
Lordship has adjourned the 20.
Huh?
Lordship adjourned.
Yes.
My lords, 30. Accusation is under 307, my lords. The injuries are simple. It was a, my lords, it's a politically foisted case. what had happened, there was a quarrel in the morning, and the allegation is in the evening he had gone with his men.
What are the injuries?
Simple in nature.
Yes.
The only problem is that he has
And-
15 antecedents. for
15
which-
antecedents have given a chart, my lords, because his wife is the sarpanch and he also is a member of the cooperative society.
The only problem that they have not disclosed whether they are on bail in those cases.
In
or
all
not.
cases, your lordships, in all cases, they are on.
Where is that declaration?
Declaration were already
Where is that declaration that you have 15 cases? Very missing.
Comprehensive affidavit in relation to the criminal antecedents
Where
of
is
the
that? Is
petitioner,
there?
that
In
is.
para 5,
Para?
5. In para 4, they have written 16 antecedents.
Hmm.
In para 5, they
Details
stated
is
in
not,
relation
nothing is
to-
given.
And in para 5, they have
Granted
stated the
bail,
petitioner
that it is
already granted
please
bail in all
submitted.
matters.
That out of the total 16 cases, 2 numbers of matters have already been
You,
become
I
infectious.
will, you file the affidavit, it will be verified and it will be released on bail.
Yes,
Let
Let
them file, right?
As-
Petition rejecting conform to allegation made by Paris also. Mr. Kango drawing the attention of this court to para 5 of the petition, submits that although petitioner has 15 a number of criminal cases, but in all the cases he has been on bail, on bail. He further submits that you are the
These are all arising out of cases arising out of political.
Almost all the cases are arising out of the political disagreement with the opposite party. And you are Sarpanch. What is that?
My wife.
His wife is the Sarpanch.
The wife of first petitioner.
First petition.
The wife of the petition number 1 being the Sarpanch. There is a political rivalry between the informants and the petitioner. Therefore, the present case has been questioned. Petitioner is in custody since 29.
23
26.
March.
20 March 2024. They have been get to the application and period of custody. Subject to the condition that the petitioner shall file a comprehensive affidavit report to trial court, as the trial court shall verify the authenticity of the contention to that affidavit and release the petitioner on bail. The condition has been fixed and so on.
Second person has 5 antecedents, so we'll file a comprehensive.
You file a comprehensive affidavit that will be verified by the trial court and he will be released. Yes.
Deeply.
31.
Based on circumstantial evidence,
Yes.
the petitioner is in custody since 4/1/23.
Evidence you got it?
Yes.
Yes.
Here, my
4/1?
4/1/23.
4/1/23. What are the
In
evidence?
investigation, there are 3 circumstances.
Hmm.
One is they have previous enmity, therefore there is a motive. Second is larceny. Third is seizure of weapon of offense.
27.
Sir. So far as
Who are the last scene?
last scene
PW?
PW19.
PW19 last scene
Again.
and last scene.
Again.
Last scene and 27.
Again.
27 recovery.
17 and
18.
PW 17 and 18.
18, those
18,
revenue inspector.
27. Under section 27. And motive?
Aniruddha Fanda.
Motive is PW
2.
2 motive.
PW
Let us see. First of all, 27. Let us see.
7. These 2 witnesses are revenue inspector. No independent witness have been examined as the official witness.
How the revenue inspector what to do with this case?
My lord, when the accused was arrested,
Been called upon to give to accompany with the accused for leading to discovery. Of the weapon of offense.
Revenue inspector. But merely because the revenue inspector, how can you dismiss?
There are independent witnesses. There are 20 witnesses who have been examined. They are witness to the motive. They are witness to the other articles seized. Seizure witnesses are also independent witnesses.
The independent
Self-defense.
independent witnesses have not supported.
No.
my lord, independent witness, my lord, the last in witness not supported. Previous-
19 has not supported.
Yes.
Yes.
2 not supported.
Two not supported, and these only 27 two official witnesses you are.
Yes, official witnesses, my lord. While
Out of 20 witnesses so far examined, how many witnesses supported except these two official witnesses, so-called official witnesses, according to her?
my lord, when the accused confessed, it was confessed before the executive magistrate. Executive magistrate
Extrajudicial confession.
not confession before the
Confession before.
Section 35.
25 hit by 20.
Yes, 25 feet, my lord. But these witness, the accused cannot claim that the evidence of these two witnesses cannot be relied upon.
No, suppose 27 is also proved.
Yes.
What about the other?
Chain completed.
Then how do you do it?
Yes, chain completed.
I take it 27 to be accepted. No problem.
Chain completed.
Then come for you. If this is the nature of evidence, what to do? That pass the order.
Evidence would have
Evidences are there, na? Give me evidence right now and do it. One is.
Again.
Draft out one is the
वो भांगी देची अकल PW 19 टा भांगी
petitioner is accused in so and so case. Allegation against allegation is FIR as per FIR is so and so. After investigation, charge sheet has already been filed and the petition has already been put to trial. During the trial, about 20 witnesses have been examined. Out of the 20 witnesses, none of the independent witnesses have supported the prosecution. PW2 has been examined to establish the motive of the crime, whereas PW19 has been examined to prove the circumstances of last scene. And PW17 and 18 has been examined to prove the recovery leading to discovery.
Weapon of
disclosure leading to
weapon
recovery.
of offense.
That is the weapon of offense. PW2 and 19, those who have been examined to prove the motive and the circumstances of last scene have not supported the prosecution. Although PW17 and 18 have supported the prosecution, but Mrs. Mahapatra submits that surprisingly PW17 and 18 were the revenue inspectors, in true sense, they are the official witnesses roped in to prove the recovery on disclosure. Therefore, she submits that the veracity of the evidence of PW17 and 18 is coming under the cloud of doubt. Mr. Naik fairly submits that in fact none of the independent witnesses have supported the prosecution as yet. So therefore, it would
And executive magistrate yet to be examined. Executive magistrate before whom the statement. Executive magistrate before whom.
Executive magistrate for what?
Confession.
Submit that the petitioner, the accused persons have confessed their crime before the executive magistrate, and the executive magistrate
Yet to be examined.
At this stage, Mr. Mahapatra submits that even if that witness will land support to the prosecution, that statement would be hit by Section 25 of Evidence Act. Taking into consideration the submission made by both the counsel, it could be safely inferred that the nature of evidence brought on record by the prosecution till date will not satisfactorily complete the chain of the sequence of event to prove the circumstantial evidence. Without entering into the merits for the case at this stage, suffices to say that the nature of evidence borne on record as of today, the petitioner is entitled to grant of bail. The petitioner is in custody since 4/1/2020. At this stage, Mr. Naik apprehend that once the petitioner will be released on bail, he may not cooperate with the trial, and the trial may further prolong. To allay the apprehension, one of the condition for release of the bail would be that the petitioner shall appear before the trial court on each date of hearing. In the event of his absence,
without satisfactory reason without the satisfaction reason to furnished by to the trial court, the trial court, it is open for the trial court to issue coercive process to ensure his presence, and the concession of being granted by this court shall also be withdrawn on the application of withdrawn by the trial court on the application of the
By the prosecution.
by the on the application of the prosecutor.
Right.
And the remaining condition shall be and the trial court is at liberty to impose any other condition deemed fit and proper in the factions of commission. Done. Rivalry. Taken on record, huh? Taken on record. Evidence are taken. Yes. Next.
32.
Appearing on behalf of Mr. Ramita.
Yes, madam.
Paso.
Paso.
32 million, that is 35 to the ganja.
35.
To the ganja. So we want to.
Antecedent, madam.
No similar nature of.
Have you said anywhere or have you filed an affidavit? File an affidavit.
CD is not with us.
So call for CD, file an affidavit. 22nd, I'll take it. 22nd of this month, file a comprehensive affidavit disclosing your antecedent. Meanwhile, he will call for CD and reach it on 22nd. Okay. Okay.
33.
Madam, offense under section 109 of BNSA along with other offenses, my lord. Charge sheet has been injury when it's constant, that is simply in nature, my lord, and no antecedent, my lord.
Now, how this matter has come up for hearing?
After that, my lord. After I mentioned my petition, my lord, after supply of police paper, I could know the
Alright.
injuries.
Yes. Injuries.
Their file, the IA copy has not been filed.
IA for preponement because it was urgent beyond vacation. He was not there. It seems. Whatever.
Injuries.
What are the injuries?
One injury caught in
Custody since?
custody since, my lord. 11 to 2026.
11 to
6, my lord.
Okay. Antecedents?
No antecedent. I have mentioned in para 7, my lord.
Very simple, very simple.
Yes, simply.
Sharp cutting weapon?
My lord.
Sharp.
What have you used?
Madam, the informant stated that petitioner and his son assaulted to his son by means of a knife, my lord. But petitioner has not assaulted his son. There was exchange of hot word in immersion ceremony of
Who is assaulted? Let us see. Your name is? Sumanto.
My lord.
Who is assaulted?
Both have. Yes, stated, my lord. Both have assaulted.
What about the other petitioner?
He has not offended, my lord.
Huh?
He has not offended, my lord. Son has not offended.
Investigation is going on.
Submitted charge sheet.
Father and son. And father has arrested, but son has not been
Charge sheet has been filed.
My lord.
He is absconding.
My lord.
That's the problem.
And this is the statement of the
Both
injury.
of you attacked and absconding. Yeah? Petitioner is accused also. Allegation is the person. So after investigation, charge sheet has been filed on 10/4/2026. The revision of the charge sheet reveals that the who has received this injury?
Injured, my lord. Sonu.
What do you mean?
Sonu bhai.
Sonu bhai.
My lord.
Sonu bhai sustained an injury in the side of his neck, left side of his neck, by a sharp cutting weapon. But the injury is simple in nature. Counsel for the state submits, counsel for the petitioner submits that the petitioner has no prejudice. While opposing bail, counsel for the petitioner state submits that petitioner and his son are the accused in the present case. Both of them have attacked the injured, attacked Sonu Bhai, causing the injury. The son of the petitioner is absconding. Therefore, the charge sheet has been shown as an absconder. Regarding it to the nature of the mediation, period of fracturing. And there are how many injured?
One injured, my lord.
Sumanto Das?
Suman Das, my lord.
You are the
Present petitioner.
You are the and although we inclined to ask the petitioner regular bill. Sorry, entering into, sorry, entity bill. Over liberty and this is regular bill what?
No, no, regular bill.
Okay, okay. Period in custody and
11/2/2026.
Yes. Sure. Okay. Modification. Yes, first.
34.
May I please?
What modification, madam?
No, 24 modification order 24/4/25/26. No? Page number 2, kindly see paragraph 2 and 3.
What
two-
modification you want?
Two party already released.
Uh-huh.
Two party already bail. First or second or not parity mention. Parity.
Parity.
Yes, ma'am.
Only parity.
Yes,
Parity is there. It's there. In accordance with the law, it's there. Two accused persons have already been, right? See, petition seeks modification of this order on the ground that two of the accused persons have already been enlarged on regular bill. Regular bill. However, this court, while rejecting the anticipated bail of order 24/4/2026, has not made any observation regarding the entitlement of the petitioner to avail the ground of parity. Regarding it to the aforementioned submission, the order is shown so is modified parity. Okay. Yes.
35.
Yes, sir.
Yes, please, ma'am. Inadvertently, the GR number has been wrongly calculated.
Which one? GR number?
God's space, Lordship.
7 of 23.
7 of 26 it has been written, but the correct GR number is 1809 of 2025.
GR number, correct. Correct. Okay. Yes, next.
36.
Date of surrender.
Surrender. Extension.
Correct.
Extension, huh? Yes.
Lordship, I am here for the modification of order dated 29/4/2026.
What modification?
Kindly go through page number 3. In view of huge quantity of ganja recovered from the petitioner. Lordship, there is no recovery from me, Your Lordship. And this paragraph directly entangled me, Your Lordship. I am not.
Sorry?
Sir, I am directly entangled me this paragraph, Your Lordship. I am not in the nowhere entangled in nowhere connected to this case, Your Lordship. I am only the previous owner, Your Lordship, of the said vehicle.
No, what exactly you want? What modification you want?
Your Lordship, in view of huge quantity of ganja recovered from the petitioner.
Oh, from the petitioner, you are saying it is not recovered from you.
Not recovered from you.
Let us consider for the petitioner by moving the present application submits that you are the owner of the vehicle.
Previous owner, I am previous owner of the vehicle.
Submits that the observation made by this court in para 5 that the huge quantity of ganja recovered from the petitioner may be modified in view of the fact that the ganja has not been recovered from you. The previous owner of the vehicle in which the contraband ganja was being.
Lordship, must note the FIR on 20th 10/2023, the vehicle already sold to one government.
In view of the same, the para 5 for the petitioner category. In view of the huge quantity of ganja recovered from the petitioner category. Okay, that's allowed.
Compoundable offense.
Yes.
37.
Your Lordship, this is a petition filed under section 482 CRPC seeking to quash the order of cognizance and the criminal proceedings initiated against the petitioner company under section 138 of the Negotiable Instruments Act. The crux of the matter is very simple, Your Lordship. The check in question, which is at page number 20, Your Lordship.
Page 20.
Yes.
Yes.
That was issued by the person in his individual capacity, not in the capacity as the director of the petitioner company. That's why it is not.
Show me 130 notice. Notice. I asked you.
Yes, sir.
Notice. Notice was issued to whom?
Your Lordship, this copy has not been served with us. Even
Not required. It was issued to the company.
Yeah, but what I have instructions from the
The
local
reply-
advocate is that it was never served on them.
That is a different story that you, they,
reply, I have also
Ah.
copy of the reply.
where is that reply?
Yes, very next page.
Find the reply, what to do?
In the reply, he has also said that I am the managing director of the company.
Then,
But your lordship, the check in question, first of all, I have not gone through the reply. I have to go through it. So,
no, it was replied by you only.
your lordship,
Replied by you.
then I need to take instructions in that regard. Because this is not,
These are tribal issues. I can't.
your lordship,
Convenience like.
but I'm trying to impress upon the fact that if your lordship have a glance at page number 20.
Can I tell you this fact now? Your case, shall I tell you the facts? You are getting confused.
No, no, not.
138 notice was given to the company.
Yes.
The check was issued by individual, that is the Sushant Kumar so-and-so.
Yes.
Okay. Check was, the 138 notice was given saying that you are the managing director and you issued check to discharge the liability of the company. You received it and replied. Thereafter, a complaint is filed against the company. And all these things are tribal. And the court has taken cognizance. You take that plea. It is not sufficient notice, whatever plea you want to take.
Your lordship, that
How will you take the benefit of that judgment, Anita Hada? You are
no, your lordship,
Anita
I'm
Hada?
relying on PJ Agrotech, which is
Anita
at
Hada.
flag B,
Show me the judgment.
which is at flag B, your lordship. I'm
Yes.
relying on para number 13 and para number 14.
Yes.
If I may read, from a reading of the said section, it is very clear that in order to attract the provisions thereof,
1 minute.
check which is dishonored would have to be drawn by person on an account maintained by him.
1 minute. Are you in hurry? Going somewhere else? Slow, go slow.
I apologize, your lordship.
13, okay. 13, read it. 13.
From a reading of the said section, it is very clear that in order to attract the provisions thereof, a check which is dishonored will have to be drawn by person on an account maintained by him, the banker for payment of
14, next. 14.
In the instant case, the check which has been dishonored issued by respondent number 11, discharging the dues of appellant 1 company and the directors to respondent 1 company, respondent company case against the appellant 1 company, for recovery of issues by other fora. It is not sufficient to attract the provisions of section 138 of the NI Act. The appellant company and its director cannot be made liable under section 138 of the NI Act for a default committed by respondent number 11. That's my point, your lordship. That is, the check in question has been issued.
Yes, let's see the complaint. What is the government?
That is the complaint, your lordship, which is at annexure 3, your lordship, starts from page number 21.
Yes.
Lordship has page number 21.
Where it is averred that the check was issued by Susanto to discharge the liability of the company. Where is that?
Lord, so far as the cited decisions are concerned, the cited decision, in the cited decision, trial has commenced. Both parties laid their evidence. They have disputed.
I've seen that.
Trial might not commence. This judgment I have relied upon today, only the had here. There your lordship will kindly look to page 20. That the Honorable Appeals Court has held, it is not the case stage when the summons were issued. In the present case, my lord, only summons has been issued.
Which paragraph you are reading?
Yes, my lord,
Para?
running page 20, paragraph 20. My lord.
Yes.
Kindly look to running page 19, paragraph 38.
Yes.
Very next page, paragraph 20. That the Honorable Appeals Court has said, at the stage of issuing summons by the magistrate, only looking to the cost.
Read it.
My lord. Paragraph 20, my lord. But despite all this, trial court issues summons to the petitioners. The mere description.
Para 20 of this judgment.
Miller.
Yes.
Page 20, Miller. Page 20, paragraph. Running page 20.
Yes.
Paragraph 20.
Para 30.
Paragraph 20, Miller. On the top.
Yes. But despite all.
Despite all this, trial court issues summons to the petitioners. The mere description and the cost title of the complaint appears to be the sole persuading factor which propelled on a magistrate to summon the petition. There is no other ground to proceed against the petition. Needless to say that a criminal court will not get any jurisdiction to proceed against a person at the mere sight of the
details on the docket sheet or the cost title. No court shall act upon the sole tag, label or baggage held on the cost title. No court shall also carried over the by the prints and dots of the veil of the cost title. The court is bound to unveil the complaint feel the texture of the contents of the text. The criminally lies on the how a person is cherished at the cost title, but how he has acted according to the contents of the complaint petition. By holding so, Lord, the page 23, kindly move to page 23, Lord, paragraph 10. The appeals court has held, in the present case, it is yet to be decided as to whether the liability was that of the company or the appellant herself. It could be personal liability of the appellant herself for discharging her debt for which she might have misused the checkbook of the company. Even under such circumstances, the offense against her could be complete is not known at this stage, since no evidence has been laid in this regard. Therefore, the inference that the liability was that of the company and she has merely vicariously liable would therefore be a premature finding. On the other hand, even if she has misused the checkbook to discharge her liability and taking advantage of the Lord, it is not possible to say anything without evidence having been laid. In the present case, Lord,
Well, pass your. Give it. Yes, next.
$38.
Yes. 38.
Your two occasions there none appear. Notice has not been issued. That is the 138 case.
Non-appeal.
That's not two also.
Second court. Dismiss for non-prosecution. Yes, dismiss for non-prosecution. Next. The petitioner has held the order dated so taking cognizance that the order dated 10/2/2021 passed by the SDJM Barampur in 1CC case number 247 of 2020 initiated by the opposite party against the petitioner and taking cognizance of the offense under section 138.
And order dated 10/2/21 under challenge.
Act non-appeal from the petitioner, and this complaint case is pending since 2020. 143 to also dismiss. Yes. Next.
39.
Mayor. Now the matter is NI Act, my lord. The
Yes.
petitioner challenges the order dated 5/6/2004 passed in the execution case number 135/2023. My lord, and also issue the warrant of attachment and the sale of the immovable property of the petitioner as per the provision of.
Where is that principal order?
My lord.
Where is that order by which the direction was made?
Annexure 1, my lord.
Yes.
Page 12. A petitioner under 21 CRPC has been filed by the petitioner, namely Rajkumar Ponda, aged about 29 years, Nalponda, so and so, and residence of RRP Associates, so and so, for releasing the interim compensation in 1C case number.
Where is the interim compensation?
Order
of interim compensation. Where is the order of interim compensation?
Page 15, Milord.
Page
15.
15, yes.
5/6/2004. Challenge the order.
Page 15,
the execution case, Milord. In execution case, Milord.
Where is the order by which the court has directed to deposit the interim compensation?
That is filing the 1CC in the CLMC 3311 of 2023. Fully disposed of.
That is very that order. Show me that order. Show me that order.
My lordship, Annexure 11/47 members. Annexure 11.
What is the consequence if 143 capital order or A order is not complied? What is the consequence? The complaint has to be dismissed.
No, no, my lordship. My lordship has already been disposed of the case bearing case number 3311 by 2023 as per Annexure 11, page 15. The direction for depositing 10% of the check amount is in compliance of
But I
statutory.
understand if he doesn't do it, what is the procedure?
So, executive court can initiate the as per 400. As per provision 421 clause A of CRPC. There are so many modes to take initiate the executive court.
Yes.
As per provision 421 clause A of CRPC.
451. Yes.
My lordship, in this case,
Yes.
my lordship, in this case, the petitioner has challenged once again after passing this honorable court in the same order once again filed in CRPC number 3127 by 2024, my lordship. One cannot come twice after the dismiss the case, my lordship. It is the principle of res judicata, my lordship.
No, that's not the issue. Issue is if this court has directed
My lordship.
to pay 10%
My lordship.
of the check amount
My lordship.
under 143 capital A.
My,
If you see 143 capital A, there is no provision how to enforce this order.
no, my lordship, as per
See, enforce
my
this
lordship.
order.
My lordship.
Therefore, you might have proceeded, but it says that if it is acquitted, it will be recovered from you.
My lordship.
That's a different story. But if he doesn't pay, what will happen? Can the complaint be dismissed? It can't be dismissed because the procedure is not provided like that. And so therefore, he has you have proceeded under 451 of CRPC for execution of that order.
My lordship.
And this order is passed in
My
execution.
lordship.
And he can challenge that if he's agreed.
No, my lordship,
Agree by-
there is a provision. The educational proceeding can follow the CRPC procedure.
That's what I'm saying.
Yes, my
If
lordship.
you have proceeded
My lordship.
as per the CRPC,
My lordship.
some order is passed now.
Yes, my lordship.
He's agreed by that order. He can independently challenge that order.
He has not completed the order, my lordship. The Honorable High Court already
That's what
directed.
the grievance is. He says that his order is wrong. He has a right to challenge that.
When the petitioner failed to comply the Honorable High Court order, alternatively, the petitioner on the lower court has challenged the same order in by way of the educational proceeding. But in this case, my lordship, tactically, in the CRMLC number 3311, he has annexed forged and fabricated document that he has paid all dues, my lordship. It is the unfair practice, my lordship.
That is a different. Then you file a
My lordship.
application under 340
My lordship.
CIPC, saying that you forged the document and move an application under 340.
My lordship, jone advocate kebe ଗୋଟେ honorable court agare forgery document ଗୁନ୍ଥିକି case କରିବ କେମିତି, my lordship? ସେ କରିବି ଆଜ୍ଞା, my lordship.
Here to decide that, I am only looking into the order impugned here, whether
My
it is
lordship.
right order or wrong order. Okay,
My
the
lordship.
petition is maintainable.
My
He
lordship.
has a right to challenge. Let us see whether the right is correct or
Same
not.
order, my
And
lordship.
the other things which you are saying, you have other remedies. You move appropriate application before trial court if he has relied upon some forged document or something.
My
There is a
lordship, maybe
petition and CRPC.
kindly permit me your liberty to me.
Why should I give liberty this time?
My lordship,
Why should
my
I-
lordship, with humble permission.
340 is there. You can very well
My
move
lordship-
application prove that he has used false document, whatever.
My lordship,
That's-
this is a high court, my lordship. This is a high court. One
Thanks
cannot
for-
play. One
Thanks
cannot
for
play,
informing
my
me
lordship.
that this is high court, but what can I do?
My lordship, he has not mentioned any document.
It's a high court to everything High Court can do without. Genuineness, it must be. My lordship. This is what I'm saying, sir. You don't get emotional arguing. My lordship, I go by law. My lordship. You have to do it. The statute has given you right. Liberty is not required. Straight away you can proceed. I have already opposed by the way of filing so page, my lordship, that the petitioner has
You are taking so many things together.
No, my lordship,
So-
it is a like practice, my lordship. I want to learn something from the simple argument, my lordship.
But whatever he has done, don't learn that, huh?
No, my lordship.
That's
Very unfair and unfortunate, my lordship.
Okay, it's all right. Let us see. How it wrong or is wrong?
Check issued for the security.
What is the amount you tell me?
71,000 something.
71,000.
No, other interim conversion.
Why don't you pay and finish it up?
No,
or
that is the
you
dispute.
lend us in deep trouble.
My lord, check with the issue to the security purpose to honor judgati case.
Those things will be decided in trial.
My lord.
You have to deposit. Will you deposit or I'll?
My lord, the interim compensation is not applicable so far as this. The petitioner is.
That I have decided already. Rejected and I ask you to pay 10%. Have you challenged that order?
My lord, petitioner is not abiding the trial, my lord. He cooperated the trial.
That's not the issue. Issue is when you came to this court, I have reduced down from 20% to 10%. Okay? Have you challenged that order? Have you challenged that order?
My lord.
Where?
In the
order passed by this court. Have you challenged that order?
My lord.
That has attained finality.
Then
you have to comply that order. As simple as that.
case, my lord. Page 49, my lord.
40?
49.
Yes. Yes. That I know. This is my order.
My lord.
Have you complied or have you challenged it? If you are agreed by that order,
my lord,
passed by me, you could have challenged that.
I mean, challenging this case, my lord, on the execution case, my lord.
As a High Court order, you will challenge in trial court.
No, my lord, in the execution case, my lord.
How can you challenge the order of the High Court in execution?
No, my lord, the what? In this case, my lord, the execution case is a challenge, my lord. I'll by the complainant.
You comply this order. Don't go into so many things.
My lord, can you see the, my lord, descendant. My lord, I'm placing that,
138 matter, you are not complying. Where is that order?
My lord.
Which paragraph you want?
Page 13, my lord.
13? 13?
13.
Yes. Which paragraph, sir?
Paragraph 13, application in my last part, my lord. In case where the law.
Which paragraph you are reading? Yes.
My lord,
15.
is to exercise.
There is no reason recorded by the land magistrate that the accused.
The exercise direction, so direction should be become twofold now. Firstfold, where an application is to made.
Where are you reading? Which paragraph?
Paragraph 13, my lord.
13, okay.
13.
Yes.
Second subpara.
Yes.
Firstfold, my lord. When an application is made, the Lord Magistrate has to apply the mind whether an application is to be considered at all. In every application that is made,
Sir, this is regarding application under section 143 capital A.
My lord.
That stage is already over. Whether the magistrate applied mind or not, all these things you have already argued. Thereafter, this court passed an order saying that, okay, not 20%, be 10%. That order you attend finality. Today you can't raise again.
The petition is not avoiding the trial, my lord. He's cooperating to the trial.
Going somewhere else, what I'm asking, why don't you answer that?
My lord.
Shall I dismiss it with increasing the 143 capital A to 20% now? Deposit it 20% by Monday.
No, my lord.
Yes.
My lord,
the petitioner undertakes to comply the order dated 19.
No, installment basis, my lord.
Huh?
For installment basis.
Come to the point now.
My lord.
Instead of arguing so much, that should have been the first argument.
My lord, for installment.
You don't have money, I'll pay it with installment.
With
Come with the first installment and Monday I'll pass the order. Yes. Come with first installment. First installment come on Monday, then show your bona fide and another 3 installment I'll adjust. Come with it.
Payment also should be kept in the court, my lord.
Sir,
But in the dispatch to the
43 provides it, once you are acquitted, has to be direction, has to be given to him to refund with money.
my lord, if I succeed this case,
I
how
can't
can
go beyond the statute, you don't make the, I'll then,
how can my lord recover that amount?
I don't know how will you,
My lord,
you go and tell the parliament. I can't do it, this is the law. What are you doing, unless shall I dismiss it with a heavy cost? I'll dismiss it with 50,000 cost. That's the only option, I tell you, don't waste time like this.
installment basis.
Monday, you will come to show your bona fide. Otherwise, it will be dismissed with heavy cost. First installment you bring, I'll try to help. First installment, Monday, you come. 10,000 rupees you bring, at least. At least 10,000 rupees. Okay.
Not, but a Tuesday, my lord.
Okay, Tuesday. Yes.
I will communicate.
Okay, let it be Tuesday. Let it be Tuesday. Come with money, give him, then the rest amount I'll fix the installment and finish it. Okay. Yes.
Item 40.
Yes.
I am for the husband. Conciliation there. Right? I'm doing. I have already.
What are you challenging?
DB. Without considering the my lord, my salary, my lord. He has 12,000. I am getting my salary.
12,000.
My lord, I have filed my affidavit.
What are you doing, by the way?
My lord, I am working as a attendant in Capital Hospital in contractual basis. I'm getting.
You have a son studying for.
Yes, ma'am.
9th class.
I am paying, my lord, for him, ma'am. For his.
How much you are paying?
My lord, the study expenditure as for the judgment, my lord. I have.
You are bearing the expenses of the for the study of your child. That's not a issue. No. That also is not paying. Then you're not paying
for both of them, my lord, for the wife and the children, my lord, the child, my lord, the lord and court will.
Show me that you are paying for the study. Pays?
Pays 12.
12.
The brief, my lord. 50 per asset.
Yes.
Hot for a
Yes.
50 per asset hearing on.
Hearing down, my lord.
That means you don't have a case.
I have a case.
Satisfy me. Otherwise, I'll dismiss it. These are maintenance, small maintenance.
No, maintenance, I am getting 12,000. The award is much more, my lord. 7,000. How will survive?
Nobody will believe this thing. Because see, if somebody is getting 12,000 rupees and engaging you, nobody will believe. Nobody will. It's not possible.
My lord, during conciliation, my lord, I have seen his client, my lord. My lord, he is affluent and my lord, friend is also quite affluent.
Looks like.
No. So 12,000, my lord.
Tell you, what is the amount?
7,000.
You pay 7,000. 7,000 is nothing. You have a child.
Yeah, I have a child. Out of 12,000, 7,000. 5,000 how more Bakma?
May I submit value?
Yes. He married another.
No.
That might be.
If my lord and friend allow me, my lord,
yes.
My lord, last occasion when my lord, the matter was before my lord Justice Nursing, my lord. It was a proposition, my lord, if I will agree, my lord, for the 6,000, the matter could be resolved there. Then, my lord, this honorable court wanted for a conciliation, my lord. Somehow, my lord, that my lord,
6,000.
My lord, tried. My.
Yeah, Bakma more.
But you have a child.
I have more Bakma. Yeah.
13 ବର୍ଷର ଛୁଆଟା ଆଜ୍ଞା ପାଠ ପଢିବ।
Then if they will stay with you, you would be spending more than that.
11,961 ଟଙ୍କା। ସେଇଟା ତ ହେଇଥିଲା ସେ ୱାଇଫ ର 7-8 ବର୍ଷ ହେଲା ସେ।
What is your qualification?
ମୁଁ metric attendant ଅଛି, only attendant ମାନେ। So that is contractual. I have filed my salary slip, man. Paragraph 12, page 12, third paragraph, man.
Third paragraph.
You can see paragraph.
Liability.
Lord trial court has stated, nobody has given his income expenditure bank statement.
No, the Lord court below has.
Trial court.
Third paragraph. in the affidavit of asset liability, my lord. What it means?
Yes,
My lord.
I disclose that his father and mother are is
Depending on that, he is having an income only 11,900 per month, my lord. He is repaying various loan. He claimed that he is paying educational bill of the child who is residing with the agri person, that the agri person having loan.
his father claimed that the agreed person is having income of 30,000.
Free claim.
6,000 you were agree with. He saying 5,000.
That is the commission said sorry thila bhi again. Khali conciliation majire posi gala again conciliation ପାଇଁ କି ଯେହେତୁ conciliation ଟା ହେଲା
he saying
5,000 ଆଜ୍ଞା ପାଠ ପଢିବ ତମ ଛୁଆ ମାନେ ପାଠ ପଢିବ
5,500 then. That's the only way. Nothing else can be done.
Maybe your lordship will that as an interim measure your lordship earlier directed to pay rupees 30,000 my lord. Vacation is coming, my lord. If your lordship will direct my lord and friend will to deposit 20,000 or 28,000.
So, whereby the below has directed the petitioner to pay monthly maintenance of 7,000 rupees for her as well as her minor child with effect from July 2024. Mr. Tripathi and counsel for the petitioner drawing the attention of this court to the Interim order submits that he have filed a specific affidavit before the trial court that he is employed as an attendant in capital hospital drawing a salary of 11,961 per month. Mr. Naik is controversial. He said that he submits that he is minor son of respondent in studying, pursuing his studies.
That is not a fact, my lord. That is not a fact.
Class 9 he is studying.
Class 7th report.
Class 7th, class 7th, and incurring heavy expenses for study. And the petitioner is not at all taking care of the expenditure towards the study of his son. At least at the same time, both the councils have conjointly submitted that at one point in time there was a conciliation. There was a settlement attempt to settle the dispute on the Interim and the respondent agreed Interim maintenance up to 6,000 is paid by modifying the Interim order, or she will be satisfied satisfied in this case. Mr. Tripathi, however, submits that beyond 5,000 is not capable of paying. Taking into consideration submission of both the parties and pleadings of the court, it would be suffice to say that at this stage the petitioner shall pay 5,500 as an interim maintenance to the agreed person, that is the opposite party and her minor child. And the main petition is pending.
No, my lord.
This modification from July 22. It is at this stage, Mr. Tripathi submits.
It's my lord, it's an interim arrangement in the DPR.
Since the trial court has directed to pay the interim maintenance from July 2024, there is a huge areas accumulated by now. Therefore, adequate installment facility to be directed to be directed so that we can make it to the entire money on some. How many installments? How many installments, sir?
10 installments. 10.
Every month, along with taking into consideration the financial constraint, revealing the financial constraint of the petitioner. The petitioner is directed to pay the entire area amount by 10 installments,
and all the 10 installments shall be paid every month along with the interim maintenance, interim directly. With this observation, the petition is issued. Yes.
I said 30,000 adjust hobo. No, 30,000.
Whatever it comes.
Should I adjust pass also?
30,000 already paid.
As per the direction of this one will be paid.
Where is that direction?
No, it is an interim measure.
30,000.
Okay, it is also brought to the notice of this court that by the order dated 6/4/2026 of this court, 30,000 rupees has already been paid.
No, it has been deposited in the London trial court. Your Lordship can direct.
You released it?
No, my lord.
Deposited before the trial court, and the same shall be directed to the release in favor of the opposite party, and the 30,000 rupees shall be factored into the area.
And the remaining order, my lord, deposit of installments by 7th of each month, my lord, it will be.
That will remain. The rest part of the order remains same. Yes.
41.
14 discuss. But I'm challenging the authority. Under the authority of the opposite party.
Challenging what?
The inquiry conducted by the ADM. I'm challenging the authority because under the Cooperative Society Act and the rules, apex authority is the registrar of the Coop Society, and he has to power to inquire the matter and any dispute raised with regard to the or any with regard to the any dispute with the society has to file a dispute under 68 of the Coop Society.
Who is appealing for 6?
6, my lord.
Service is completed. Process you filed?
Yes, ma'am.
Okay. Service report.
So,
AD from opposition. AD from opposition not yet received. It is awaiting. Service awaiting.
my grievance against the authority who has conducted the inquiry beyond the prayer of the opposite party number 6. Your Lordship kindly see the annex for 3.
But opposite party number 6 will be aggrieved. Obviously, that is the reason notice was issued.
Yes, madam. Your Lordship like that. So also Lordship directed to Government Council to take instruction with regard.
Have you obtained instruction?
My lord, I have written a letter to that who has made inquiry that he has no authority, madam. As per the 65 Society Registration Act 65, Cooperative Registration 65, he has no authority, madam.
Your Lordship.
Till then, he has not turned up, my lord, to discussion for the finalization of the counter, madam. He has no authority. Despite that authority, he has made the inquiry and he has directed to payment for the.
What is the MP in order by which the inquiry was?
Inquiry report, my lord.
Inquiry report. Where is that inquiry?
And he said 11.
11, huh?
11.
You are agreed by that?
Yes, madam.
11.
11. And this, not that, your Lordship, on compulsion, collector has directed to deposit 75,000. Also, we have filed a miscase. IA. We have deposited on compulsion. Well, there is no alternative.
65 you are talking about?
Yes, ma'am.
60.
Provided under 65.
Inquiry by the registrar.
65 is very clear that the society may at any time has own motion can inquire the matter. The register of the society.
Yes.
The ADM has no power. This is my letter to the ADM. Come and for discussion. Why you have
procedure where document
overstep your
land.
jurisdiction.
65, na?
My.
Every sub-registrar on the registering customary document relating to property also product copy. Now, what are the facts?
Fact is that your Lordship, the OP number 6, he was a daily wages peon. Daily wages peon, madam. And he was removed. He is claiming that 2015 and 16, he has made an application before the collector that I have not received some part of salary. So that is why I am saying, my lord.
Wait, I am looking at the what? Society registration act, they are giving registration act. I am looking.
Society registration act.
Cooperative society registration.
And he has a grievance that the money is not paid. You are the, you are the.
He has opined that he has not received it.
Received.
Only he has claimed, 13-10-19 ତାରିଖରୁ ପତ୍ର ଆସିବ ସମିତିର ସମ୍ପାଦକ ମହୋଦୟ ଆମର ଦରମା ନ ଦେଇ ଅଟକାଇ ରଖିଛନ୍ତି. But he has said, inquiry said ଯେ 15, 16 and 17 is not paid. He himself said that I have not received this allowance.
That is the merits.
No, yes.
That is on merits.
Exactly. That
I will not get merits.
Nowhere in the inquiry report it is said that our only place. But the ADM and the collector.
Which section you said?
65 mile.
65 of
Cooperative Society Act.
Cooperative Society.
And then say 62. Then any dispute.
Society registration act.
Can it get before the under 68 before the registered cooperative society? He has made an application before the
inquiry by the registrar. Registrar may at any time of his own or by himself or a person authorized by him by writing hold that inquiry into the constitution of the financial decisions also. An inquiry from it falls under which category?
Yes.
B.
B.
He may no, which category? B. He may summon any person who has reasons to believe that has knowledge of the affairs of the society to appear. Now, what is the nature of the complaint? Whether
he said that I have not received some salary.
Whether
he has
whether the nature of the complaint, whatever the nature of the complaint,
I'm reading out the
whether an inquiry is required.
No, absolutely not. If he is aggrieved by the action or inaction of the society, he has to raise a dispute under section 68 you lordship can see.
68 yes.
Before the registered cooperative society. Thereafter inquiry will be caused under 65. He has not done anything. He has simply filed a representation before the collector. And an inquiry was conducted by the RCS. It found that everything is okay. Annexure 4.
Annexure?
Annexure 4. Yes, the inquiry report of the allegation.
What is the amount due?
Amount is 75. 75 already paid on compulsion.
Okay.
I have filed one IA, you lordship can see. Now they are saying the money which he has withdrawn from the bank account, that will be also paid to him after 10 years. Very funny.
Let it come on 19th. Service is abated. 19th. Because some monetary benefit is to flow. Otherwise, I'll dispose it up on that day. There is nothing in this matter. See, if there is a dispute, 68 is there.
Yes,
your lordship may dispose of the matter. How can but see, a main agreed person is that respondent number 6.
Because of
notice has been issued without
which cannot be disclosed, my lord. ADM is known to the opening number 6.
Those things are, you know, what happens.
Now the amount which has withdrawn from the account.
I'm not going into merits. What I'm trying to say is you have to follow the procedure. If it is not paid 68, you raise a dispute and get it adjudicated.
Yes, ma'am.
But you can't invoke 65 and start an inquiry and say that it paid. You can't do that. That's not the scheme of law. That's not the scheme of law. So, since on such
a dispute case.
On certain days, on 29/4.
I have filed an IA.
I know, that is the reason I'm putting a 90.
Yes,
I want to dispose it, I'll tell you.
Now they are compelling to pay another no discussion shall be taken till then.
I know once no course of action, then this writ petition will be pending for 20.
No, fixing a date, you lordship.
I will dispose it up 19th, I'm telling you.
19. So in the meantime,
I made up my mind.
In the meantime, they will come.
Oh, within 2 days, what will happen? I don't know, 29/4/2026. Notice was issued to the opposite party number 2. Although the registered post has already been dispatched, but the AD has not yet been received. In the interest of justice, leaves the matter on 19th. It's made clear that no further adjournment in any cost shall be granted.
Yes.
Okay.
My lord, 18.
19th. 19th. Thereafter, good password.
Password item 3.
Yes, sir.
My lord. I am for the instrument.
Yes, who is for what is the offense?
Well, this case, when sexual assault is there, that's followed by money extraction is there, and miscarriage is also there. That effort,
there is now threat to the informant for life. For which,
What are the allegation? Tell us, see.
my lord,
Yes.
allegation is 69, 89, 350.
No, tell me the factual allegation.
Factually. My lord, the informant is a working lady, my lord. And
Assurance to marry.
the agency is working under the lady. And a worker of that agency caused sexual harassment to the.
No, that's not the allegation. Allegations are that he assured to marry and had a sexual relationship.
It is later on, my lord. It is later on.
What is the age of the victim?
My lord, age of the victim is 38, my lord.
38. What is the age of this man? 27.
27, man.
You indulge in the relationship and thereafter what to do?
No, my lord.
And all making all allegations thereafter. This boy is 27. You are 38. 10 years senior.
That is the question, my lord.
And then you did all this thing and now you say.
My lord, there is poisoning, my lord. There is poisoning.
There are hooked up stories.
My lord, kindly have a glass. There is poisoning, my lord.
Where is the allegation of poisoning? You show me in the FIR. Where is the allegation? If there was poisoning, you show me in the FIR. Where is poisoning? Where have you said poisoning? Where have you said poisoning?
My lord.
It is very detailed. How many pages complaint just see? 1, 2, 3, 4, 5. 5 pages complaint.
My lord.
Now, where have you said poisoning? Now you are bringing so many things.
My lord.
And
Page 4, my lord.
relationship has gone wrong. Therefore, all these allegations.
Relationship is, my lord, lateral. Primarily, there was a sexual assault. Thereafter, relationship built up.
I think
it is admitted fact. Relationship built up later on, and it lead to marriage also.
I think
but there is poisoning, my lord.
Poisoning where we have said, where have you said that poisoning? That's what I'm asking. And all allegations are relationship, WhatsApp message, this happened, that happened.
Page number 4, my lord.
You had relationship, she denied to marry. That's the
page number 4, my lord.
4. Yes. 4 of your petition.
3 and 4.
Petition.
Typically, पहले खाइबा को तोले तेबे खाइबे आउ मरिजा कहबा को आउ जोर करके मो पार्टी खोली की पार्टी रे भागले.
All these things story built up. Where is the petitioner?
Melody,
petitioner. Let him come. We'll see. Let him come. I think you reconcile. Better you reconcile. Why don't you?
Well, can you have a glance this?
All these things I have seen. What is the stage of investigation? Stage of investigation?
Stage of investigation, my lord, is in nascent stage, my lord.
164 statement recorded. All the facts which you have written in the complaint, it looks like completely exaggerated.
It looks
completely
like it's a relationship and it gone wrong.
It is gone wrong. Therefore, all the stories are now, cooked up stories, imaginative stories, and everything you put in there.
Document, my lord. My lord, the medical reports of the victim, my lord. Have a glass.
Let him come. Let him come. Let him come. After lunch.
Oblige, ma'am.
So item 3. Item 3 minutes. I'm sorry, Manoj, I wasn't there at the time of calling.
Yes.
No, I'm for the petitioner. Your Lordship's last order, the notice was issued to the informant. The informant's counsel has also appeared and along with the informant.
Yes.
This was relating to section 69. were committing an
Apart from
offense. of
69,
promising-
there are other.
There is another offense, my lords, of miscarriage, which they say.
Termination of.
Causing miscarriage without consent.
Yes.
That was, and the other offenses which are under section 3 and 351.
But what he
that
was
is-
saying is, show me that medical thing which you are showing, that you have administrated poison.
It's, I'm hearing this for the first time. Let me-
Is it part of the?
It is not part of this. The miscarriage thing is a part of it.
No, but in the complaint, it
In
is
the
written
complaint-
that you forcefully
Medicated.
administrated. Huh?
Forcefully administered medicine. For pregnancy has been terminated.
It was, that was for the pregnancy.
What do you want to show from this?
Poison.
Where is that poison? First page?
First page and second page.
The smaller one. Where is the poison part? Yes. Gotcha. This is you filled it up. That is what you told the doctor.
That is an examination.
Yeah, but it's not examination. This is the sleep, outdoor sleep. Once you went there and you say that I have been poisoned, then the doctor writes it. But what is the outcome of the test? From the test you show me that the doctor found poison. Yes, what is the stage of investigation? What have you got?
Charge sheet filed, but keeping investigation open.
Is there any allegation of allegations are there? Is there any medical evidence
Medical evidence.
regarding poisoning?
No, my lords.
Huh? Let's see, you might not have given this thing. Let's see. CD is there. CD is there. When you file the charge sheet?
Charge sheet filed on 10/4/26.
10/4/26.
10/4/26.
FIR is on
11/2/26.
Investigation open.
Charge sheet, have you shown him as a absconder? What? Show me. Has he cooperated with investigation? His name is Binayak Patro. Just see that column.
Yes. Hello?
See that column.
That is column has not been given. Place it. Okay, there it has been written.
Why have you kept the investigation open?
That has not been mentioned, my lords, only. No.
What about the whether he has cooperated or not? Something must be there.
Charge sheet copy 9.
Charge sheet copy you have?
Like on.
We also don't.
Final form copy টা আছে। Only in case there is a returns he has filed And
In the case diary, is there an indication that he has cooperated or anything of the sort?
no, not.
Let the copy of charge be placed on the report. Please the matter. Interim of continue.
Is he accused?
Yes. Yes.
I'll solve a copy on
I
it.
have a copy of the bail petition along with the annexes to the learned council appeal for the meanwhile. Huh?
Interim order.
Already interim boil has been granted. Then
We were staying together.
Putting it after vacation is fine.
We were staying
After
together.
vacation. Either I'll make it after it or withdraw it. Yes.
अरे नहीं ना तो इलेक्शन ना कौन कोई पॉलिटिकल शासित नहीं पॉलिटिकल लिख दीजिए देखो एक लिख दीजिए सबमिटेड है कि एटलीस्ट फॉर
Weekly.
the bail format of bail
21, huh?
20
very small matter.
There are some small matters are there. Let that be
27
concluded.
27 masse.
Small matter will finish.
21 that is the 498 304 is.
It will take little time.
Very right. But a material language. They are relying upon one exhibit 5 and there basis भी नहीं. How did they?
Anyway,
27. 27.
27.
हाँ, कर दो. ये रहा ना अगर
That I got that one.
लग रहा है.
Yes. No, let him.
The offenses of 341, 320, 3 of IPC. The SI for 1 month for 341 and 6 months for 320.
Yes. 341 and 323.
Yes, sir.
Who is injured?
PW8. PW8 is injured.
PW8. Evidence of PW8. Yes. Read. Tell me the facts, what are the facts?
Let's say, the initial the fact is the prosecution was going on. The victim is the working lady in the hospital. Oh.
It said that the injury knife forehead.
That's last item 41
Read it from there. Why are you getting? Tell the facts. Let him do.
Let's say the prosecutor stated that
Yes.
the incidents were held in front of the house of Pabitra Hota. This appellant was a concern nearby the Tati in front of the Pabitra Hota's house restraint of PW8. That is the father of PW7 and becoming this appellant.
Yes.
So the injury was on the head and other parts of the body. That's been the
Who is the injured?
PW8.
Okay.
That's been PW7. The informant. That's been he is the witness. Said that. That's been PW7 para 1. He stated that up to 1 to 2 p.m. in front of my house, the incident was happened. And hearing Hulla, I came out of the house and saw accused being accompanied by two other, namely Vaikunta Barik and Ramapatra, assaulting my father holding lathis. And Lordship in cross-examination, para 3, she stated that my father and father of accused Sushanta Pradhan are 3 brothers, and there were case between
Who all are the eyewitnesses? Tell me.
Lordship, in
PW8 is the injured, huh?
Yes, sir.
Who all are the eyewitnesses? PW7 and?
PW4 and 5. 4 and 5 are the eyewitnesses.
7 also. PW4.
Lordship, 7, she is not
PW5.
present in that time. She was in school because in cross-examination.
7 is the informant.
Yes, sir. Lordship, she is a daughter, but in her cross-examination, she told that she was in school, but
Who is the doctor?
2 and 6.
Are you? 9.
9.
10. Yes. Yes. Read PW4 first. Eyewitness.
It is clear now.
He has not supported the prosecution. He says that I do not know anything about the incident. Therefore, you will declare hostile. Declare hostile. Okay? Hostile.
PW5 also declare hostile.
Hostile, huh? Yes. PW5 also hostile.
The PW2 also turned hostile.
Who is PW2? Doctor?
PW2 is the doctor.
PW2 is a doctor.
PW2 is hostile.
PW2 is a main a doctor who examined the.
No, he has said that lacerated wound and. He is not declared hostile.
No, I didn't like that.
PW2 is not hostile.
4 and 5 there are 2 eyewitnesses and 8 is the hostile. The 8 is the injured.
You read 8. Read 8. PW8.
PW7 is my doctor.
PW7.
Let him read. Let him read.
PW7 is my daughter. I know the accused. The incident took place on 9 so and so at about 1 to 2 p.m. on the road in front of my house, Pabitra Hota, which is distance about 100 feet from my house. After returning from carpentry work from Kantapara hospital, I was returning from home at that time when Jayanta Barik holding lathi lead me on the road. Thereafter, when I wanted to go back, my cycle accused person holding Thenga attacked me from front side, whereas their companions Vaikunda Barik and Ramachandra attacked me around my back side. thereafter on different part of my body, causing injuries on my forehead, just after the right eyebrows, head, right arm, and both the legs. In view of the assault, I fell down on the road. Accused person holding a body pick up.
Then he says that Vaikuntha Parik and Ramchandra Patra attacked me.
Attack me
Different parts on my body and causing the
on the
injuries
front
my
side of
forehead.
yes,
Right,
forehead.
so I fell down. Accused person holding me this also makes so. And he, PW8 only takes the name of Vaikuntha and Ramesh.
Yes.
And what is the role attributed to Prashant Parik, Sushant Parik, Ramhari Patra? The story goes like this. Jayanta Patra waylaid the PW8. Thereafter, Vaikuntha and Ramchandra assaulted. Isn't it? And there are many injuries. Okay, but the Vaikuntha Patra is appellant number 1. What about Prashant Parik, Sushant Parik, and Ramhari Patra? What are the allegations here? PW7 also says Vaikuntha Parik and Ramapatra assaulted my father, pulling lathis and so also. Let us come to
PW9. PW9 cross examination in para 5.
Yes.
It's been fourth line. Para 5, fourth line.
Read pura the entire para. I have not examined one type of program.
There is a count.
So I examined Ramakanta Parik and conducted investigation. Due to non-availability of Pravakasata, I did not examine him. So I have not issued any notice to which line here?
Para 5 from fourth line.
Yes.
I have invested officer in the counter case. Also, para PW7 has not stated before me that at the relevant time while she was taking meal inside the house after returning the school, she heard that holla and came out to the spot. She has also not specifically stated before me that her father sustained injury on his back, right leg and chest. However, she stated that her father sustained injuries on other parts of the body along with head. And after that, PW8 also has not stated before me that the accused person had attacked him before from his front side. It is not a fact that investigation shows.
These PW7 and PW8 has not stated that fact to the police.
Yes, sir.
That's sure. Let us see the impugn order. Why the other accused persons are obtained. And Ramesh Patra is not even convicted. Not even charge sheeted Ramesh Patra, Ramesh Chandra Patra.
the affair, there are three names. One Sushant Barik, Boykuntha Barik, and Ram.
FIR it may be, but what is the evidence against other people?
Thereafter, that Ram Mohari and Prashant Barik, thereafter they are added. I have seen that affair, there are three names. One Sushant Barik, Boykuntha.
No, use eyewitness account. There are two witnesses. They are hostile. PW 7 and 8 are the main witnesses.
7 is the daughter of the PW8.
Yes, but neither the PW 7 nor the PW 8 has taken the name of the other accused person. So except Boykuntha and Ramchandra. Ramchandra is not even charge sheeted. Ramchandra is not charge sheeted. And the name of the other people, where from you got it? A1 will be convicted and PO will be granted to A1, and whereas 2, 3 and 4 accurate. Look. Nothing is there against the 3 of them. Nobody has taken the name. What is there?
That fact means that the present injured PW8
And both PW, see, eyewitness turn hostile. PW 7, 8 is the injured. PW7 is the daughter of the injured. Both of them said that Boykunto and Ramesh Patra has assaulted. And Joyanto waylaid and these two people have assaulted. Joyanto and Ramesh is not even charge sheeted. Only Boykunto. And insofar as the other accused persons are concerned, nobody has taken the name. I don't know how these people are roped in.
There are the PW7 is the process that stated that the PW8 and 1 and 3 the three brothers.
Yes.
34.
34.
41.
Yes.
Item 51 also fine.
30?
41.
Sorry, 34.
31. You have to read.
Yes, Your Lordship, the prosecution allegation in short is that the deceased person was working in the sweet stall of the accused person, and he was not paid regular wages, and he was also not allowed to go to his house. On this basis, there was a 97 CRPC application which was filed by the wife of the deceased. Thereafter, the deceased was rescued, and he there was a dying which is there was a statement by him recorded by the emergency officer come the executive magistrate, and that was treated as an FIR, and on that basis the accused persons there was a complaint filed against the accused persons, and he was sentenced to undergo 6 months of imprisonment under section 323 of the IPC. Your Lordship, before we move ahead with the rest of the prosecution witnesses.
323.
Yes, Your
He
Lordship.
died.
Yes,
Yes,
they
Your
were
Lordship.
charged under section 300 to 34 IPC. Acquitted. Only convicted under section 323. After he was rescued by the police, he lodged an FIR that on the previous night he was assaulted by the present appellants by means of a lathi. And the FIR was treated as dying declaration. His statement was also recorded by the subdivisional magistrate, which is marked as Exhibit 13. And the London trial court held that there was no intention or knowledge. Was
323.
Yes, 320. That's the reason 323 conviction. 6 months.
You should be happy, madam. If you get it.
Yeah, and they have already undergone 5 months.
Already undergone.
5 months ଯାଇଛନ୍ତି 6 ମାସରୁ.
Whereas the once you get inside the evidence and all, something may come out and you will be in trouble. Notice will be issued for enhancement. Why are you getting into 5 months you have already undergone?
Yes, sir.
Out of 6 months.
Yes, sir.
So I'll reduce down to period already undergone by maintaining conviction. 6 months. After all, there is a death. There is 97 proceeding initiated. And it is a fact that the deceased was beaten up by you.
Your Lordship, but that is like in the evidence that cannot be established.
Why?
Because Your Lordship, first of all, the MOI that is alleged to have been seized, the seizure witnesses have turned hostile, and the MOI was not even produced before the doctor to ascertain that the injuries that
He died in next day only.
No.
Lordship, after 12 days he died.
But he was rescued from your custody.
Your Lordship, rescued, but the family members, they went to the police station and there he was found. But nowhere it is mentioned that from where the deceased was rescued.
He was rescued on 12, died on 25/3. And the cause of death is due to injury to brain. He never complained that he sustained an injury on head. So probably for that reason, trial court acquitted of the charge under section 300. That is there in paragraph 16 of the impugned judgment.
There was no external injury on head. It was a subdural hematoma.
Internal injury only.
Internal injury.
Already under already under.
Oh, President.
41, item 41.
41, huh?
Yes. The appellant is convicted under section 470 and sentencing to pay fine of rupees 30,000 only. 30,000.
Fine of 30,000. 470. Acquitted of the charge under
Acquitted on
493.
493,
470.
313 and 376.
What is the facts? IPC. Sentence, no sentence.
May I please?
Or is there 30,000? What do you say? There is no period. Sentence, no what period. 30,000 you have to pay. That's all.
Reduce the sum.
Are you incident of which year?
2001. Let's see.
If you are aiming at an acquittal, think over. How many of you are there?
One.
Only one of 30,000. 30,000 in the year
2001.
2001. 2006. 2006, 30,000. Now it should be increasing. Value has increased. 30,000 rupees in that time, 2006. It has now 30,000 is nothing. Is it a case for acquittal? Chance of acquittal?
PW6 is the victims. They have stated that they are residing as a husband and wife after marrying in a temple. Subsequently, he deserted her. That's why she has
lost the
recorded
affair.
an order of conviction under section 470.
Where is cheating then?
He did not actually marry her.
But that is some other offense.
493, but
493
to
maybe.
record an order of acquittal. Lordship may kindly see the
What is
judgment.
this logic? I don't understand.
Paragraph 8 of the interim judgment, soft copy, LCR page 1 to 7.
Paragraph 8, huh? Yes.
Now coming to the charge under section 493 IPC, the prosecution has to prove that the ingredient that in this case the complainant was aged more than 30 years during the relevant period and working as an Anganwadi worker before that she married the accused at Shiva temple at Dangazhalo secretly, and after the said marriage she as well as the accused Saroj are staying in their respective houses, and she had not displaying her as married woman as per Hindu custom, and both were in visiting term to the place and other as per their suitability. With the aforesaid version of the complainant, in no circumstances it can be presumed that such belief in her was induced by deceit on the part of the accused Saroj.
Yeah, logic. 4 DPX is also dropped. All that the prosecution has succeeded to establish charge. But 370 is not discussed.
417, paragraph 10. Relating to the charge under section 417 IPC, it is found that complainant speaks of a relationship with accused Saroj and they are living as husband and wife at both. Though the evidence adduced on alleged marriage at Sibo Temple, Dangijola are not present to rely upon, the evidence of the complainant herself and that of PW2 and 3, one of the occupant of a neighboring quarters in veterinary colony, both are quite present to come to a conclusion that complainant and the accused Saroj were free in their physical relationship and even both staying together. It is obvious that one unmarried woman will entertain a man for such cohabitation only with a hope of a marital status for her. Irrespective of any inconsistency and discrepancy in the evidence of the prosecution, the materials on record, including the photographs relating to Saroj and Sarla, clearly reflects hope of marriage or marital life given by accused Saroj to complainant. The evidence of the complainant PW6, her father PW3, that Saroj left his quarter at Baud on his transfer clandestinely, and in spite of their efforts to search him out after moving from place to place, reveals a clear case of deception of accused Saroj to the victim, which amounts to an offense under section 417 IPC and he is liable for this.
Read 415, read. Do you have the book? You should carry at least the criminal manual. 415. Read 415.
House trespass in order to commit offense.
415 house trespass.
415.
Cheating. Whoever by
What is 417? You tell. Why you are convicted for what?
Punishment for cheating.
Cheating. Whether on the facts of this case, on the basis of evidence, cheating definition, you are falling under definition of cheating or not? That is the case.
Yes.
Read cheating. Yes.
Whoever by deceiving any person fraudulently or dishonestly induces the person so deceived to deliver any property to any person or to consent that any person shall retain any property or intentionally induces the person so deceived to do or omit to do anything which he would not to do or omit if he was not to so deceived, and which act of omission causes or is likely to cause damage or harm to that person in body, mind, reputation, or property is said to cheat.
So whether the definition is coming or not?
Yes.
Coming. Which part? Which part?
Page 14 of 130 of the 130 page number 130.
Yes, read it.
In relating to the charge under section 470 of IPC, it is found that complainant seeks of her relationship with accused Saroj and they are living as husband and wife at both. Though the evidence adduced and on alleged marriage at Sibo Temple, Dangijol are not consent to rely upon the evidence of the complainant herself and that of PW2 and PW3, one of the occupant of a neighboring quarters in veterinary colony. Both are quite consent to come to a conclusion that complainant and the accused Saroj were free in their physical relationship and even both staying together. It is obvious that one unmarried woman will entertain a man for such cohabitation only with a hope of a marital status for her, irrespective of any consistency and discrepancy in the evidence of the prosecution. The materials on the records including the photograph relating to Saroj and Sarala clearly reflect hope of marriage or marital life given by accused Saroj to complainant Sarala.
the evidence of the complainant PW6 or father PW2 that Soros left his quarter at both on his transfer clandestinely, and in spite of their efforts to search him out after moving from place to place, reveals a clear case of deception of accused Soros to Sarala, which amount to an offense under section 470 IPC, and he is liable to for the same.
Yes, what do you say? I don't think it's
It's a fit case where he should have been convicted under section
in
493
the
also.
absence of that, how can you in the absence of 395?
Deceit has cleared by intention and deception are the ingredients of section 428.
You can't stress so much. Okay.
Arises out of a complaint.